Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and hopefully, my mic did not blow your eardrums off today. Hopefully that didn't happen. Oh my goodness. So, what's up, guys? Tonight, we have a little bit of a show. We have a little bit of a show to cover. Some things, some stuff and things. We've got, I don't want to call it a smorgasbord because that'll make me hungry. But we've got some new stuff. What is this? Oh, lovely. This is the problem with growing my hair out. Now you guys know why I have a fade. My hair cowlicks all over in the back, and so it just like goes, as it grows a little bit, it goes shoots straight up. Anyway, so we've got a couple different topics tonight. We've got some legal news type topics, some law news, some culture news, a little bit of different stuff here and there to kind of get the juices flowing. We've got that. We've got a very, very big thing. We've got a very, very big thing happening to Wizards of the Coast right now. And I'm hesitant to overstate things, but they're in a real trouble with this lawsuit. Unless there is some documented counter assertions and counter evidence, we'll say. This lawsuit brought by Margaret Weiss and Tracy Hickman, who are the authors of the DragonLance novels. The original DragonLance novels, Dragons of Autumn Twilight, Dragons of Winter Morning, Dragons of Summer Dawn, or whatever it is. Spring other time of day. I don't know. It doesn't matter. The original ones, the ones that matter, the ones that led to the War of the Twins, these are like the genesis of D&D fiction. I believe these like predate Salvatore's books with Raceland, or with Drizzt and Elminster. I mean, we're talking about massive titles. Fantastic art, great characters. Lord Soth, is such a devious villain. Raceland, Harriman, the big, dumb, good-willing brute. You've got, oh gosh, I'm trying to think of who the other characters were. The side cast. I don't want to call them a side cast. They were important people. Many of them being very, very powerful in their own right. Hasselhoff, yes. Tanis Half-Elven. Oh, thank you. Great characters. So they get this. You guys heard of Dungeons and Dragons? Like, it's a big thing. And they've had some back and forth stuff going on. Weiss and Hickman, Weiss, I don't know how to pronounce her name. They approached D&D back in 2017. They approached Wizards of the Coast back in 2017 and said, give us a license for Dragonlance and we will make 3 new books, a new trilogy, a new Dragons trilogy too. I think the first one was Dragons of Deceit. The next one was Dragons of Fate. I don't think they titled the third one. They're like, we're going to do 3 books. And guys, like, these books were going to be coming out like this year or next year for the first one. 1 book a year. Boom, boom, boom. First one's done. It's written. Second one, draft is done. Rewrites were in progress. Wizards of the Coast shut them down middle of this year. So, the amount of work, how do I put this? The amount of work that, and I don't mean writing, right? Writing a novel is a lot of work. But putting together a book deal for a book that's going to sell millions of copies for a massive property through a major publisher is a big undertaking. There's lawyers everywhere. There are, companies involved. There's more than just the main parties. There's promotions to consider. There's international considerations like translations. And it all is predicated on a license agreement. The whole idea of a license agreement is that I give you permission for a period of time to use this property. It's mine. I'm going to take it back. But while you have the license agreement, it's yours. It's like a video rental, right? I can't just come back to your house after you rent a video and take it from your VCR and be like, no, sucker. Like, we had an agreement. You have it for this period of time. That's the license. They granted him a license. This license was going to go on and persist for something like 10 years after the first sale of the third book. First sale of a copy of the third book, 10 years after that, or 2032. Told you, they won a year. Boom, boom, boom. This year, next year, in 2022 was going to be the release of the third book. Third book would have sold its first copy. Anyway, so they would get 10 years of that. And so the purpose of the license is it gives you time to do stuff, to set up things like, other publishers, to set up merchandising, to set up, it gives you time to consider options for sequels and stuff like that if you need it. All right. Wizards of the Coast just pulled, well, they didn't cancel the license. That's the thing. They're trying to weasel their way out of it. Trying to weasel their way out of the license. And it effectively cancels the books without canceling the license. Well, there's this cool thing in law where it's like if you're trying to breach the contract, but just being like, how? It's not really a breach, though. It is a breach. If you make the contract impossible to perform, then you've breached the contract. That's what's going on here. And we're going to read through a bunch of this lawsuit. It's 21 pages. We'll skip some of the really boring parts. And we'll show you how they do it. And I'm going to tell you why Wizards of the Coast is in real trouble on this. It's not just, and it's not just me saying they should be in trouble. You'll see their actions and you probably will agree that they should be in trouble because it's just a trash way to deal with contracts. But the real hitch is where they are is a bad place to do this. The state of Washington has a lot of things going against them. And so that's kind of the kicker. So we're going to get into that. We'll read through it. I'll tell you why I think it's a really good suit. And of course, this is predicated on only having in our hands right now a complaint. We just have the one party side. There could be something else to it. But what they would have to produce to overcome this complaint is big. I will be kind of surprised if Wizards actually fights this. And they don't go ahead and settle and do the books. I hope they settle and do the books. I really do. I want to read the new DragonLance books. I would love it. I would much rather that. If they go through this lawsuit, those DragonLance books probably aren't coming out. I mean, they're suing in part for specific performance, which means finished contracts, you chumps. But, and things like this, they don't always win on specific performance. And if they don't, it'll probably be the end of it. We'll never see them. Because they wouldn't be able to do it. Now, if the court just upholds the license agreement and says tough titties to Wizards of the Coast, we might get them. But either way, this is a big indication of some of the problems at Wizards of the Coast. And yes, this does have to do with the wokening. So there's some get woke, go broke stuff. And this won't break Wizards of the Coast. Even if they lose a lawsuit outright, you know, it is damages in excess of $10 million, but Wizards is owned by Hasbro. It's a multi-billion-dollar revenue company per year. They'd weather it. They'd live through it. But it's a nasty tarnish, and it'll piss off a lot of fans if Dragonlance doesn't get books, and everybody knows, oh wait, these were done. These were almost done. That's a big thing. Okay, so we're gonna talk about that. Then we're going to wrap up the stream with some more of this law discussion in the context of the Supreme Court. We're going to watch Scalia, part of an interview with Scalia, and it's about 15 minutes long, so I'll make sure and drag it out an hour. And he's talking about his originalist approach, his judicial philosophy of originalism, and this is kind of a preview for some of those, you know, the more shows delving into judicial philosophy. And I'm focusing on Scalia right now because I think a lot of you probably like me, like Scalia and his approach, and think that that's like a very good way to do constitutional law. But we're probably going to get into some others, including some of the liberal justices as we go, to see what that approach looks like from other perspectives. So we'll do that. We'll do that at the end. And yes, as part of the news, guys, we're going to talk about Trump. We're going to talk about Hunter Biden. Those things are part of the news segment. We've got that. We're going to lead off with that in just a little bit. In just a second. All right? So, we're going to go through those stories a little bit. But yeah, like I said, we're going to close the show with some Scalia talking about his judicial philosophy. And then, this will be kind of like an ongoing thing, is exploring the judicial philosophies that apply to, SCOTUS. And the two main ones, the big ones that are at odds, are originalism, which branches from textualism, but they're similar, and then the evolutionary philosophy of the Constitution, the evolving Constitution, the living Constitution, as it were. And Scalia makes very good arguments as to what is so ridiculous about the idea of a living Constitution. So we'll get to that near the end. You didn't get notified? Well, welcome to YouTube and me, buddy. Also, we could probably talk. Vic had his announcement today on Unlocked, I believe. I didn't watch it. I don't watch his Unlocked streams. I read about it, though. Basically, I think people were expecting like an announcement of something. But he didn't say that. He said he was going to talk about what God had revealed to him over this stuff. And he kind of, analogized his situation with that of Joseph, which I think is a very good analogy. A very, very good analogy about not that he is going to rise up and everyone will bow before him. I think that's the wrong message to take from that. But I think if he's seeing himself as Joseph, he's talking about Joseph being on top of the world and maybe being in his own mind a little bit. And kind of a little full of himself, perhaps. I don't know. I'm not accusing Vic of that, but I think maybe that's the perspective he's taking. And then, Joseph being betrayed by those around him and humbled for a long period of time, and realizing that what he thought was God's plan for him wasn't exactly what God had in mind, but that God had God had something different. So anyway, to those of you who may have been hoping for some sort of like announcement, you know, that probably isn't what you want to hear. But for those of you hoping to figure out where Vic is at mentally on this stuff, what the past year has kind of done to him, you know, if that's his perspective, I think he's in a pretty good spot. Kind of weather this stuff and see it as an opportunity for personal growth. No, I don't mean Job. I mean Joseph. You guys aren't even Bibles, are you? No, not Joseph and Mary. Joseph and the Donny Osmond, guys. Donny Osmond. That Joseph. The one whose jacket was as gay as Vic's pants. That Joseph. Oh my god. I'm going to come through this screen and I'm going to strangle all of you for your bad biblical knowledge. Oh my gosh. We've got embarrassing levels of bibliophile going on. This is Joseph and his brothers. His dad loves him more than all the other brothers, and he has dreams. He interprets them, and he's like, "Oh man, all my brothers are gonna bow down before me." And the brothers are like, "Wait a minute now, let's kill this idiot." And then they don't kill him though; they just throw him in a hole, and then they sell him to Muslim slave traders or something. Not Muslim. This is a joke. This is pre-Islam. They sell him to slavers from Egypt. He gets sold into an Egyptian house, Potiphar. He gets Me Too'd by Potiphar's wife, thrown in prison falsely, falsely accused, thrown in prison, interprets the dreams of two cellmates. One of them, he's like, "Oh, bro, you're going to get killed." The other one, he's like, "Yeah, you're going to get out. Everything's going to be fine." He's right. And then Pharaoh starts having dreams. And then the guy's like, "Oh yeah, this guy Joseph, you know, he can interpret your dreams, Pharaoh." And so then he does. Then he leads Egypt. And then like hundreds of years later, the neurosurgeon, Ben Carson says that the pyramids were hermetically sealed tombs that Joseph used to preserve grain, because Ben Carson is the dumbest smart guy around, maybe. That's the story. That's the Bible story we're talking about. It's and it is a good analogy for Vic, if you take it, you know, if you take some of the steps out. But anyway, so that's what he was talking about Moses Malone. Okay, but anyway, so that was Vic's thing. But let's do this. Let me read super chat, and then we're gonna go into some. I gotta pull up these stories. Got some stories here. News stories. What do we got? This one. Oh, damn it. Don't you hate when you put the address in the wrong window? Okay, anyway, we've got Brian and Terrence says, "Nick, I want to thank you for all that you do." Oh, you're welcome. Past year has been the most stressful time of my life, and your streams have been one of the few joys and escapes I have left. Thank you, Nick. Hey, Brian, hang in there, buddy. Lots of us are having really stressful times. COVID's been a bitch. A lot of people are out of work. A lot of people are separated from family, separated from their activities. So lots of people are with you, man. We'll get back to normal. Don't worry about the shit of the world. Everything will be. I'm hoping. I'm hopeful. I'm an optimistic man. everything will kind of balance out. Just wait till this election, man. This is what's ruining. It's compounding the ruin. If this wasn't an election year, if this had happened in 2017, this wouldn't be a big deal. None of this would have been a big deal. But so just hang in there. After this election, things will level out. It doesn't even matter who wins as far as that goes. Stuff's going to start getting back. Oh, on that note, Ty and I are doing a presidential debate stream on Thursday. We may have another lawyer on. I gotta check with him and see. I gotta be careful because adding too many people to those streams is a mess. I am planning on doing an election night stream. I will have a Canadian here in studio with me, a Canadian here in studio who is an election analytics expert up in Canada, I guess. Or I don't know if he's an expert. That's what he does for a job. Does that make him an expert? I will have him here in studio, and then we will hopefully have some other guests as well throughout the night. We'll be talking about all this stuff. Peacock, I see you guys. Believe me, I see you guys asking me about Peacock. Peacock, hopefully, I'm trying to set up a big brain panel with Peacock, with Josh, Mr. Birch, this week, either Friday or Saturday. I'm hoping to set it up. I've been in contact with all of them. I'm just trying to get confirmations from somebody, from some people. But yeah, so we have that coming Friday. Not Josh the lawyer. So that will be hopefully a big brain panel either Friday or Saturday, just trying to lay it out. Not Josh Moon. And then so we're working on it. I'm working on it. Kendra Wynn is a very good question. I want to get Kendra an uncivil law on. So I'll be working on that very soon too. So that's where we're at on those things right now. I'm trying to get a hold of Corey Feldman. I don't know why I never thought to reach out to Corey Feldman before, but I'm trying to get Corey Feldman. I would love to get him on the show. I don't have any progress on it right now other than him liking one of my tweets about it. But I'm going to keep kind of dropping hints at it politely to see if I can get Corey Feldman on to talk about Hollyweird and culture and all this stuff. So I hope it doesn't get weird. Oh man, if Corey Feldman's on the stream, I hope it does get weird. Oh, Brian, the crown, my daughter stole it and I had to steal it back, but it's up in my room right now. So anyway, we'll see how it goes. Joshua Vidrine says, Nick, I've been given the opportunity to hold and guide a discussion in my church this Sunday about loving your enemy. Any pointers? Going to be mostly men in the group, if that helps. Gonna be a bit political too. People probably don't think I'm very good at this topic. But that's okay. That's fine. Here we go. My biggest pointer about loving your enemies, and this is one of the failings of the modern church. This is one of the failings of the modern church, okay? Is we say we're doing this in love to the other person. And the big issues on this are love the sinner, not the sin, right? Love the sinner, hate the sin. And I agree. However, if you ask the sinner if they're feeling love from the church proper or whatever, many of them will say no. Many of them will say no. It's like, well, but they're just they're just doing this in love. So I don't know how, but I would say that a temperature check that says that the other person isn't feeling the love, maybe we're not loving the way we should. That's all. I don't know what the better way is. I'm not presuming to have the answer. But often I think we get very sure that we are loving, and other people don't see it that way. And if they're not feeling or perceiving the love that we're giving off, maybe we're wasting our efforts in that direction. Maybe we should do it in a different way. But that's me. That's my thoughts on it. I'm not the best. I'm not the best at portraying loving of enemies, though. I kind of go online and talk shit about people all the time. So who knows? So there you go. Insert clever name here. But Josh, if you wanna send me an email or something, we could, or a direct message somewhere, we could talk about it a little more. I'd be happy to. Insert clever name here says, does this make the Vic story Vic in the Amazing Technicolor Dream Pants? Yes. Yes, it does. Trademark it, run it, let's write it. We'll make it a musical. Vic can take the lead role, but he can't play himself. So there's that. All right. Now that we've started all sorts of biblical critical discussions in the chat, let's go. Love your enemies unless they're fat and idiotic. Rackets 2020. Soul in the Lich nailed it. There you go. Perfect. Let's get to some weird stories. And then some big stories and all that stuff. Fat shaming is love. Stay away from the bacon. Give it to me. All right. Detroit woman who was wrongly pronounced dead by medics dies at hospital. So this is the dead woman dying again. And this is kind of like an interesting story, I guess. So we'll talk about this, and then there are legal ramifications to this, possibly. So, a Michigan woman was mistakenly pronounced dead by medics at her home. Michigan woman was. I mean, who was? Has died in a children's hospital. Paramedics were sent to Tamisha Beauchamp's home in Southfield outside Detroit in August, where she was pronounced dead and taken to a funeral home in a body bag. When the bag was unzipped, the woman was actually alive. Jeffrey Feiger, a lawyer representing Beauchamp's family, told the Detroit Free Press that the woman died because of massive brain damage caused by her being declared dead and deprived of oxygen. He said previously that paramedics may have declared her head. How many typos are in this? Because she had cerebral palsy. You can see here, she had some issues. In this undated family photo provided by Erica Lattimore through Feiger Law shows her daughter, Tamisha Beauchamp, with her brother, Stephen Thompson. There's a lot of different last names going on there. In Southfield, Michigan, Tamisha Beauchamp died Sunday, October 18th, at Children's Hospital in Detroit. Jeffrey Feiger said in a news release, Beauchamp was declared dead only to be found alive at a funeral home in August. She'd been hospitalized in critical condition ever since. Our whole family is devastated, the family said in a statement. This is the second time our beloved Tamisha has been pronounced dead, but this time she isn't coming back. Several of the first responders involved in the August call to Beauchamp's home have been placed on leave, but have denied any negligence. So, here we go. What do you guys think? What do you guys think? I mean, this is a lawsuit, right? Like, this is a lawsuit. You can't like declare someone dead, put them in a body bag, Johnny, drag them to the funeral home, open the bag and go, oh shit, they still alive. Like, you can't do that. That's not a good look. So here's the hurdles. Colonel Crayon, I believe that picture is before the brain damage. She had cerebral palsy though. So I guess other brain damage. So here's how you do this. This is probably, I mean, this is a negligence suit, but it kind of really is going to fall into sort of the medical malpractice sort of area. All right. But so what you have to do is you have to establish a duty. So negligence works this way. It's duty, breach, damages, and the court being able to compensate. So you have a duty to do something, breach that duty, that breach causes damages, and then the court can fix the damages, usually with money. That's how wrongful death works. In medical malpractice, it gets a little bit more specific. You have to show a duty of care, standard duty of care in the field. So what the medics are going to have to do is the paramedics are going to have to show that they applied the standard duty of care to this person in checking to see if she was alive. They're going to have to lay out their procedure for it. Don't know if they have any cameras or anything like that. They'll have to lay out the procedure that they did, what measures they took to see if she was alive, and then figure out how, while the paramedics weren't able to figure out she was alive, whoever opened the body bag was, and how that could possibly not be a breach of the duty of care. But the duty of care is specific to the field of medicine you're dealing with. So in this case, you know, it's going to be the duty of care that a paramedic would provide, not like some specialist doctor, not something else, not even a generalist doctor. This is a paramedic's duty of care. So did they do what a paramedic would be reasonably expected to do in the circumstances? And if they didn't do that, if they breached that duty, then what they have to do is prove that the damage that happened to her, namely the death, the brain damage and the death, was caused, in fact, by that breach. Now, just zipping someone in a body bag doesn't necessarily mean they're going to die. I don't think body bags are airtight. Maybe they are. I'm not sure that they're tight enough to really restrict airflow. Maybe they are. I'm not a body bag expert. This will be their hurdle to overcome. All right? It'll be their hurdle to overcome. But they'll have to go ahead and prove 51%, because it's civil court, by a 51% measure, that whatever the paramedics failed to do, however they breached their duty, is what caused the harm. So if the failure to properly identify that she was alive caused them to put her in a body bag, which restricted oxygen and caused her to have brain damage, well then sure, you've got that. That's a pretty obvious chain. If it just prevented them from providing further treatment, like, oh, if they would have noticed she was alive, they would have hooked her up to oxygen, something like that, then they still could have a breach of the duty of care, which would have been to follow up with certain medical procedures and trauma procedures and take her to a hospital. That could still be it. If they link the death to something else that's unrelated to it, then they're not going to win. And then the court would compensate for money. Now, the hard part is, sure, there's some level of monetary loss here because she's been in a hospital. Oh, excuse me. Since what? August? Been in a hospital since August. So there's a lot of monetary loss there. That's a problem. Obviously, that's expensive, but it's not that much. And the kind of unfortunate thing is, we're not supposed to put values on people's lives, but we really do. And someone with severe cerebral palsy isn't a... How do I put this? It's not a massive economic loss. Does that make sense? Because she's not out there earning a lot of money. Not like building a 401k. She wasn't a CEO of something. It sounds terrible, but it's true. In the same way that if you negligently cause the death of like a 75-year-old, it's probably not as economically damaging as causing the death of a 25-year-old. Especially a 25-year-old with a medical degree, for example. That's the worst. Oh my God, if you're a drunk driver, just pray that you never run over like a child prodigy doctor with 2 MDs or something, because then you're done. You're gonna go, you're out forever. But she's not going to be a big economic income earner. So the value of this lawsuit, it really kind of depends. I'm not sure what Michigan's other damage theories are. There may be some punitive damages involved, but really they're not looking at a huge payout. It'll be significant, don't get me wrong. Any death is a very significant payout, but yeah, so I thought this was an interesting story because, like, Detroit woman who was wrongly pronounced dead dies. Well, okay, good. The undead have risen and been defeated. Perfect. All right, let's get the next one up. We're gonna do a Trump story real quick that I saw the other day to talk about, and then we'll do Hunter Biden. Yes, we are getting Hunter Biden. This was good. This is an opinion story. And it's the reason I'm bringing this up is because this is something I was talking about. I've done some videos talking about Trump's taxes in regards to the criminal court. And, Trump basically trying to keep his taxes from being an election issue. And the main reason I think Trump wants his taxes to not be an election issue is because most people don't understand how people who pay taxes do taxes. I literally mean that most people do not understand what a net taxpayer's taxes look like, much less what a billionaire's taxes. Okay? So that's why he doesn't want them to be an election issue. In fact, there's a story today that Trump has a secret Chinese bank account. A secret Chinese bank account, which it's not secret. And there's perfectly reasonable explanations for why Trump Industries, who does business in China and was trying to open hotels in China, has a Chinese bank account. Because you have to. So that's the thing. 400 million in debt is not an issue? No. Lots of people are very in debt. That doesn't have anything to do with the president. Excuse me. But, and especially, again, billionaires leverage assets all the time. It's not, it's just, I don't know. It's not really worth arguing about it. But unless you understand how millionaires, billionaires, business owners, corporations do their taxes, how they do carry forward losses for a period of 20 years, how the fact that like their taxes aren't even done for 2 to 3 years, like your taxes are due on the 15th of April, but millionaires' taxes aren't due until October 15th. I mean, yours aren't either, really. You can get an extension for like $80 or whatever. But these people are doing this constantly. And then when you get into the idea of like having taxes that span 100 different business lines that are audited, your taxes are a starting point in a negotiation process. It's not that simple. It's not a 1040 EZ. You just file in April. And again, if you don't understand how that works, the way that billionaires do their taxes is going to look infuriating. And it is. It's dumb. They don't like it either. They don't like it either. Okay. So, anyway. So, how Trump is turning his 5 court losses into a win opinion. So, somehow, in his desperate effort to keep his tax returns out of the hands of prosecutors, because let's be honest about this, though Trump is losing, the move to have his tax returns from the prosecutor in New York is purely political. It's an abuse of his prosecutorial authority. It has no basis under any sort of proposed criminal activity. There's no cause for it. He's just trying to use a method to get to the taxes that they weren't able to get through other methods. That's obvious. Now, unfortunately, and this really is kind of unfortunate, he'll probably eventually win this fight. And I don't mean Trump. I mean the prosecutor in New York will eventually win this fight. Because for some reason, even though there is no articulable crime, no probable cause for a crime, not even reasonable suspicion of a crime, there's no articulable suspicion of crime attached to Donald Trump's taxes. I want people to understand what's going on with this, because when you say that a grand jury is looking for taxes to search for criminal activity, in this case, they haven't articulated any suspected criminal activity at all. They just think that there might be some there somewhere. And so they've requested documents to see if maybe he has committed a crime. This should just be a violation of your 4th Amendment rights, your 5th Amendment right to self-incrimination, or protection against self-incrimination. These are rights that you should be able to exercise. He's not accused of a crime. Not even suspected of one at this point. They're just doing it. So let's be real about what it is. It's just a move. And again, you don't have to like Trump to recognize it. I don't care. I don't really like Trump that much. I think people get a misunderstanding of me because I really dislike Joe Biden. And I don't like the fake stuff about Trump and the hysteria about him. So people think that I'm like a big Trump fanboy. I'm not, but it's fine. It doesn't matter in the end. You don't have to like Trump to understand when a prosecutor is abusing his office to achieve a political purpose. And that's what's been going on. And now all the people who know this, like this author, Ellie Honig, they know that that's what this prosecutor's doing. And they're mad that Trump is playing the same game. They're mad that Trump is he's using the court process to delay the political impact of the taxes. They know it, but they're still writing as if they don't. And that's a disingenuous part. That's the shit that makes everybody look bad. All right? That's the problem here. Because I believe Ellie Honig is a lawyer. Checking. Yeah, it's also a guy. He works at a law firm in New Jersey. Lowenstein Sandler. Here, I'll pull him up for you. Okay. Here's our writer. Ellie. Come on now. Oh my goodness, I'm bad at this. There you go. There he is. A dapper professional or whatever. All right. This is a lawyer. This is a lawyer at a big firm. He's going to say some stupid stuff in just a second. But he knows that this is a sham, and it is. He knows it, okay? So, somehow in his desperate effort to keep his tax returns out of the hands of prosecutors, President Donald Trump has lost in federal court 5 times. And remarkably, even after those stinging rejections by the courts, It's still not over yet. Trump is now down to his final shot to prevent prosecutors from getting his tax returns. Maybe not, actually, but he'll almost certainly lose on the merits. But if the goal was simply to drag this dispute out beyond the election, then he'll have won despite all the losing. But herein lies the problem. The goal of the federal prosecutor wasn't to get Trump's tax returns. The goal of the federal prosecutor, as Ellie Honig is begrudgingly admitting in that opening paragraph, was to get Trump's tax returns before the election. He knows exactly what's going on, and he's writing a lie. Because this is why I don't like these people. This is why I don't like lawyers, right? I've said it before, they're the worst people on earth. This guy is fully aware of the lie. Kyle Cowden says, having been a medic for 15 years of my career, these jerks need to be prosecuted. The complete disregard for their duties and negligence is beyond anyone I've ever seen. This lady scared the crap out of the funeral home guy. Bet she did. Oh shit, zombies! Goodness gracious. Overcloud says, love you, mini law lord. Stop feeding these few the scrapes of the table and show your plan to draw upon the lesser known genetic capability of the CDN. We want you. I wish I could do real law, but I'm a Canadian, but I'm a worthless Canadian. I'm so sorry. I'm so sorry. But anyway, so last month's explosive New York Times expose gave us a hint about why Trump might be flailing so hard to prevent prosecutors with the New York County Manhattan District Attorney's Office from obtaining his tax returns via a subpoena issued to the accounting firms Mazars USA. The Times piece raised a panoply of serious questions. How on earth did Trump twice pay only $750 in federal income taxes? I don't know. What's your name? Honig? Ellie? How did GE, a multi-trillion-dollar company, how did GE pay $0 in corporate taxes for several years? I mean, actually, I do know. Do you? They leveraged loss, they depreciated real assets, and then they carried forward that loss for several years, even though they had increasing revenue. It's how they do it. You categorize and realize loss at specific strategic times. If you've ever worked with an accountant who does more than the Jackson Hewitt guy at Walmart does, then you know exactly what they're doing. You realize your losses strategically at a time when you can build that up and carry it forward, and you can... I'm having a burtation. I'm not really. And you can nix out some of the gains that you would have in the coming years. You can carry forward a loss 20 years. Congress wrote that law because sometimes people have really, really big losses. So how did he pay $750 in tax? Probably by mitigating his gains with a bunch of losses. By the way, all of you people shat on Donald Trump for his past failures in business. If he's the worst businessman ever, he doesn't have all the gains that he needs to pay a bunch of taxes. If he's the worst businessman ever, he's fraught with losses. One way they encourage people with money to risk that money. If you take the losses on this thing, then you can actually carry those losses into the next couple years to offset your gains. So we want you to risk money. We want you to take chances. We want you to open businesses. We want you to make jobs and pay people. That's what he's done. You don't have to like the guy. Again, you could think his businesses are trash. But if they're trash and losing money, then that's why he's not paying. And it's pretty obvious. How can Trump justify a payment of over $700,000 to his daughter Ivanka Trump as a consultant? I don't know. Maybe because she's a high-paid consultant. She was on his show. She was on, what was that show? You're Fired or whatever? The Apprentice. She was on the show. She's a businesswoman in her own right. What, are you not allowed to pay your children? All sorts of people pay their children. Did Trump properly obtain a tax refund of over $72 million in 2010? No idea. Maybe. That was right. Again, 2008 through 2010 were some of the worst economic years in recent U.S. history. Very possible. Very possible he got a tax refund of over $72 million. I don't know what's in it. Doesn't really matter to me if he did. If he got it, here's the real question. If he illegally got a $72 million tax refund a decade ago, why hasn't the IRS prosecuted him? Has it, like, you'd think that the IRS, who's in charge of collecting the revenue from the people and, of course, paying out tax refunds, would go, whoa, when they see a $72 million check go out, they go, well, I mean, we just want to double check it. We just want to double check it. But yeah, RW Bimby says refund means it was his money they gave back. Right. So here's the thing. Again, if he paid and, you pay estimated taxes when you reach certain levels of income and you're self-employed or whatever, you pay estimated taxes. He very likely in 2008, 2009, 2010 paid estimated taxes on perceived earnings and then went ahead and realized that, oh, he vastly overpaid because all businesses underperformed for 2 years under the strong leadership of Barack Obama through one of the worst economic crises and one of the worst economic recoveries in U.S. history. There's very reasonable explanations as to how it could happen. Is that the real story? I don't know, but it's certainly a plausible one. It's certainly a plausible one. How and when does he intend to repay the hundreds of millions of dollars he appears to owe to various unknown creditors? You know what? Here's the real. Let me red pill you guys on this. Let me red pill you guys on this. He doesn't ever have to. Not because he's Trump, not because he's president, but because credit is a gamble. You don't have to pay back your credit card either. You'll face the ramifications of it. You'll face the ramifications of not paying it back. Your credit will take a hit. Someone might sue you. But if Trump doesn't ever pay it back, what happens? Oh, he's a shyster. Okay. And he's a shyster. He didn't pay it back. I know of a guy. I don't know him. I think he died before I was old. Used to do business with one of my family members. And now he was always faithful in paying one of my family members. But he didn't like banks too much. And this guy was an oil guy. And what he would do, he would go to a bank and he would borrow like $4 million to open an oil refinery. Reasonable, right? Nice capital loan. And then he'd just never pay him. Never pay him back at all. And then they would sue him and he'd just file bankruptcy. And then like 2 years later, he'd go to another bank and he'd borrow $4 or $5 million for operating capital. And the person I know asked him, they said, okay, wait a minute. How do you never pay these banks? And how do you then keep getting loans? And he says, because banks are greedy. And if you walk into a bank and ask to borrow a huge amount of money and tell them you'll pay whatever interest rate, and you can show on your balance sheet that you have these physical assets, they say, sure, and they loan you the money. And then you just don't pay them. There you go. Was that guy a bad businessman? Yes. Did he make millions of dollars? Yes. Did he pay it back to the banks? No. It's just how you do it. Just do it. So, how's Trump going to pay back hundreds of millions of dollars? Doesn't really matter. He should pay it back. That's the moral thing to do. That's the proper business thing to do. But if he doesn't, it has no basis on bearing on his presidency at all. It's also not illegal to not pay back a big loan. Like it's unlawful in the terms that it breaches a contract. You're violating your agreement. You don't go to jail for it anymore. We got rid of debtor's prison. You'd have to get to criminal fraud levels. That's really hard to do. Really hard to do on this stuff. So anyway, plus repaying loans, again, of a certain amount, becomes a negotiation. Things that are normal for you or I become a negotiation when you're a billionaire. Like, again, your taxes. Your taxes are a negotiation when you're a billionaire. Your debt repayments, they're a negotiation. Well, extend the term, add a percentage point, or we'll re-amortize. You know, I know I'm in default, but the business had a losing year, so we're gonna have things are turned around. We're gonna have a gaining year. Let's go ahead and let's clear out any existing balance, any unpaid balance. We'll clear that out. We'll tack it on the back end of the loan and add 5 years to the term and add a percentage point. Okay, negotiated. We'll take that. Make a good faith escrow payment of 3 months and we'll do it. Okay, done. Boom, it's a negotiation. You can't do that with your credit card most of the time. A lot of you can. If you don't know this, you can do stuff like that with your credit cards and your personal loans, but it's a lot easier when you're a billionaire to do stuff like that. One reason is you have someone else who does it for you, but two, they see your capital and they think, yeah, they'll be good for it. So, I just want to point out that, and again, Ellie Honig, this guy knows this stuff. Ugh. What do we know about him? He does white-collar criminal defense. This guy does the things. He does white-collar criminal defense. This guy absolutely knows this stuff. This guy does this stuff. That's his literal business. Oh my goodness. That's good business, by the way. White-collar criminal defense, if you can get into it, in a place near New York, Chicago, or LA, you will make all of the money. You'll make all of the money you could imagine. All right. Let me get a couple of these. Lorik Project says, hey, Nikki, started watching late. Decided to let the chat know that the Wizards of the Coast office is across the street from a low-quality strip club. Oh, man. They should, as long as they're not hiring the low-quality strippers as models for the art. Fox McCloud says, is Trump an R slur, or is he smart enough to move all of his money around? Make up your minds, journos. Yeah, it's a good question. Billy Stone says, funny how AOC and the Democrats want to forgive billions and billions in college loans, but want to demonize Trump not paying back his. And actually, there's no indication that he's not paying them back. They're just like, well, he has a bunch of debt. He has hundreds of millions of debt. Okay. He builds buildings, big, tall ones that cost a lot. Not that surprising to me. Mithran Emrys says, but Legal Eagle totally implied that Trump did illegal tax stuff. And he's sponsored by a suit company. He wouldn't allow his personal bias to influence his understanding of the information, would he? It's funny because we don't actually have Trump's taxes. There was like, what, one page, something like that, or a couple pages of one of the tax returns was released to the New York Times, and they and some like 27-year-old journalist wrote about it who's not a tax expert. All right. Crazy thing is, the IRS probably doesn't even know if he's committed a crime because his taxes are that complicated, and so is the IRS tax code. All right, here we go. Let's keep going. When the DA's subpoena calling for the tax returns first landed, Trump responded by raising an absolute immunity defense, arguing that he cannot even be investigated criminally while in office. This was a failed This is a failed thing, but it ended up being a smart move, doing this first. Raising a novel defense of absolute immunity to criminal subpoenas took a lot of time. Federal courts did not agree, to put it mildly. First Federal District Court Judge Victor Marrero, I appeared in front of him many times, and he's as even-keeled a jurist as you'll find, forcefully rejected Trump's argument, calling aspects of such doctrine repugnant to the nation's governmental structure and constitutional values. 0 for 1 for those keeping count. What? 0 for 1. What? A panel of the Court of Appeals for the Second Circuit concurred, quoting the Supreme Court's warning in the Richard Nixon tapes case that Trump's argument, if accepted, would gravely impair the basic function of the courts. 0 for 2. Squirt. The Supreme Court then granted cert, meaning it decided to take on the case. Once again, Trump lost. This time, it had to hurt a little extra to see both of his own Supreme Court nominees, Justices Neil Gorsuch and Brett Kavanaugh, side against him in a 7-2 ruling. Probably didn't hurt that bad, in all honesty. I'm guessing he was prepared to lose after losing at the appeals court. At this point, Trump was over 3, but it wasn't over yet, because while the court rejected the president's specific absolute immunity argument, still left the door open for him to make other arguments against subpoena. So down we went to the district court to begin another go-round. This time, Trump tried new legal arguments. He claimed the subpoena was overbroad and meant to harass. It is, and it is. Make no mistake. That's right. Whether or not they make the legal standard of it, both of those things are true. Both of those things are true. And he met with just as little success. Judge Marrero rejected Trump's challenge, 0 for 4, and the Court of Appeals did the same, 0 for 5. Trump now has asked the Supreme Court to take up the case for a second time. One way or another, this will be the last stop. I doubt the court will take the case. The Court of Appeals correctly and pointedly noted that the subpoena calls for run-of-the-mill documents typically relevant to a grand jury investigation. This language seems purposeful. The Supreme Court generally steers clear of run-of-the-mill disputes, and if the court does take the case, then I see no realistic chance they come out in Trump's favor, given the merit of his arguments and the court's prior 7-2 rejection of his initial claim. I don't know if this is a fair assessment. I think if the court does take the case, there's a chance that they actually do a 5-4 swap. I really do. Because overbreath and what was the other thing? Oh, overbreath and harassment are very, very different issues to an absolute immunity defense. The absolute immunity defense is a novel defense. The overbreath and harassment issues are related more specifically to the fact that this is a New York City prosecutor going after tax returns from entities that don't even do business in New York, looking for crimes that they can't prosecute because it's outside of their jurisdiction. That's overbreath and harassment, and it also involves the president with a politically opposed prosecutorial office. Like those things are different issues than a novel argument for absolute immunity from any criminal subpoenas for a sitting president. Those are very different questions. And for him to treat them so blithely the same is disingenuous. Trump almost certainly will lose this legal battle at some point, likely soon, but ultimately he will prevail simply by jamming up the system. He has appealed and reappealed and reappealed. As a result, the Manhattan DA likely will not have the tax returns before Election Day, and the general public certainly won't see them by then. Nor should they. Credit Trump for this much. He has figured out a way to turn 0 for 5 into a win. Now to your questions. So I also wanted to go through some of these questions with you so you guys get an idea for what this guy thinks as well. Can Congress reduce the number of Supreme Court justices or only increase? Okay, we don't like. Yes. The short answer is yes. Congress can do this, although the long answer is much more complicated. We don't actually know that the Judiciary Act is a constitutional law. Like, there isn't really a Congress sets the limit clause in the Constitution for how many justices there are. And I don't believe that aspect of the Judiciary Act has ever been challenged, because it hasn't had to be challenged. It probably will be challenged if Biden wants to pack the court, or if Trump wants to pack the court. Because without the buy-in of Congress, you'd have to have both houses and the president be in alignment to pack the court. If you don't have that, then the president just starts appointing nominees. And if you just start appointing nominees without actually changing the Judiciary Act, there's a question. Well, can the president appoint a 10th Supreme Court justice when the law says they can only be 9? Actually, the real question is, here's the constitutional question. Can Congress, through the Judiciary Act, prevent the president from appointing a 10th justice? Or any justice? And I don't see how they can. They can simply refuse to add them in the Senate. They can refuse to confirm them in the Senate. But if the president appointed a 10th justice and the Senate confirmed it, like let's say tomorrow Trump did it and the Senate confirmed it, would the Judiciary Act stop that? I don't think so. I don't think so. And he doesn't really get into that as much. He just talks about how, like, if you decrease the number, you'd have to have people die. So, anyway, his explanation is rather lackluster. But this one got me. This one is why we're here. Mithran Emmer says, so using the system the way it's meant to be used is jamming up the system. Does he tell his clients, we lost, sorry fam, when the district court goes against him? This is disingenuous to say the least. Oh yeah, I'm sure he does that for his white-collar clients, his white-collar crime clients. Listen, I know you're a multi-hundred millionaire who needs defense because of alleged investment fraud, and you're paying me $12 million to take this case. But you know, we did lose at the district court, so we're not going to appeal. Ever. You'll just go to prison then. All right, here we go. Does the president have authority to issue a nationwide face mask mandate? Probably. This is how you know this guy's a dork. First of all, you say it depends. That's the lawyer answer. Second, you don't say probably. You would say maybe or possibly. You give less of an indication than probably, because they probably don't. And what he uses as his evidence is ridiculous. So let's read this. Federal law gives the Secretary of the Department of Health and Human Services the authority to issue regulations that, in his judgment, are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the United States or between states. The President, as head of the executive branch, can instruct the Secretary to exercise this power. That's great. That's all well and good. The problem is you're now going to talk about mandating people to an affirmative act of wearing a thing that implicates their expression. At the federal level, we're not talking state level. You're talking every single person, and you would have to show that mandating every single person off of federal property outside of airports and ports of entry, somehow that me walking around my hometown is preventing the spread of COVID state to state, because the federal government has no business about my spread of COVID in the state. They can't do anything about it. So we're getting into real, like, dormant commerce clause territory here. And it would be a very, very difficult thing to uphold constitutionally. This is so dumb. That federal government's authority here is extraordinarily broad. For example, law permits the Secretary to require inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated. Logically, if the regulations can go so far as to require extermination or destruction of goods to prevent the spread of disease, then it should also permit a mandatory order that people wear face masks in public. No! Those are different issues. The first issue is a Fifth Amendment taking. If the government requires you to kill a bunch of animals or property or destroy a bunch of stuff because it's contaminated, they have to compensate you for it. That's a taking under the Fifth Amendment. They've deprived it of all value. Now they have to pay you a reasonable market value for the thing that they took. That's a Fifth Amendment takings. This is completely different. There is no Fifth Amendment takings of a mask. You're under a different area of law. You're under the right to free expression. You're under compelled speech by the government. These are not the same thing. You can't just blithely put together, well, if the secretary has the power to do this, he must have the power to do that. But they're separate areas of constitutional law. They're not even in the same fucking constitutional section of questions. Ugh. This guy pisses me off. In this one, in the line of succession, as Secretary of State or Speaker of the House become president after the vice president? This is actually kind of an interesting answer that he gives here. I'm not going to go through it though, because I don't think he deserves it. Oh, look at it. Look at him. There he is. He's got his little knife ears. Some sort of tree prancing elfkin or whatever that guy is. Gross. 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 That guy sucks. Okay. Let's do this. Let me I'm getting there. Let's see. We've got the full video. Full hour. Oh gosh, slimy lawyers just piss me off. All right. All right. You guys want to talk about Hunter Biden? You want to talk about Hunter Biden? We'll talk about Hunter Biden. Full video. Rudy Giuliani drops bombshell text message allegations against Joe Biden and his son, Hunter. Okay. Former New York City mayor and current attorney to President Donald Trump, Rudy Giuliani, comments on new revelations regarding his investigation into Democratic nominee Joe Biden and his son, Hunter. Hunter's alleged actions in dealing with overseas nations, what Giuliani claims he has done with the evidence he has, and more via Newsmax. All right, let's check it out. This is 15 minutes, and then we're doing Wizards of the Coast. So, oh my God. You're muted. I got it. Hold on.
Or maybe you haven't because big tech is trying to censor it. But Hunter Biden's hard drive has been discovered, turned over to Rudy Giuliani. And, well, the rest is not yet history because, well, people don't know if they want to really look at this stuff. And they're not asking Joe Biden about it. By the way, he's not denying it. Huh?
Guy's
right?
annoying.
Remember that. No, that's exactly the kind of thing that Joe Biden
Let's just
promised
get to
everybody
Rudy's part.
Was not happening. There's that. Also, there's an email outlining a proposed deal to do business with China. And
here's the email text says, Dear Hunter, thank you for inviting me to DC and giving an opportunity to meet your father and spent some time together because he's Russian, you know. It's really an honor and pleasure. As we spoke yesterday evening, would be great to meet today for a quick coffee. Uh-oh, that sounds like a Saxon. What do you think? I could come to you office somewhere around noon or so before or on my way to airport. Best Vadim Pojarski. I don't know if I'm pronouncing that right.
10% would be reserved for the big guy, and everybody seems to think that's Vice President.
Wait a minute. Okay, so here's another one. This is from Robert Biden. Here we go. My understanding is that the original agreement with the director was for consulting fees based on instructions alone. A rate of $10 million per year for a 3-year guarantee, total of $30 million. The chairman arranged that deal after we went to Miami to a much more lasting and lucrative arrangement to create a holding company, 50% owned by me and 50% owned by him. Consulting fees is one piece of our income stream, but the reasons this proposal by the chairman was so much more interesting to me and my family is that we would also be partners in the equity and profits of the JV's investments. Hence, I assumed the reason for our discussion today, in which you made clear that the chairman would first get his investment capital return and the profits would then be split 50-50. If you saying that is not the case, then please return to us the original deal, $10 million per year, guaranteed 3 years plus bonus payments. That doesn't, I mean, let's see what the next part.
Former Vice President Biden at that point. Also, there's all kinds of unpleasantness in there, photos and, well, Hunter's adventures around the world. But we have to emphasize this. Newsmax has not investigated this. We're reading the material from the New York Post. Rudy Giuliani is the president's attorney. He's also America's mayor. He has made these allegations. He's looked at the hard drive.
He's also America's mayor.
This needs to be looked into. Unfortunately, too much of the media will not. I wonder why that is. But for now, Rudy Giuliani joins us once again. Mr. Mayor, great to have you back.
Oh, Robert
Newsmax.
is Hunter's first
tonight,
name?
Sir?
Okay.
I'm okay, Craig. How are you?
I'm good. I'm good. A couple of things. We have gone through the New York.
Let me just say, I do not like Craig from Newsmax. I do not like his delivery. I'm not a big fan of it. It's weird.
New York Post, we've seen that, but I want to get you first. I heard a little bit of your radio show, and there's some rumblings that Hunter Biden at one point, and I'm hearing that the Senate might be on to this, something like $800 million may have gone through Hunter Biden's Morgan Stanley brokerage account. What can you tell us about that, please?
Actually, Greg, I'm not as familiar with that as the Senate committee is. I know the rumors. I've talked to 2 of the lawyers involved.
Okay. I'm sorry. I'm autistic about this a little bit. Rudy Giuliani's teeth, like his bottom row is flat, but his top row is like this. What's up with that? What's going on there, Rudy?
So here's what I know. I know that there's a Morgan Stanley account, allegedly, involving at least Hunter, his partner, Devin Archer, who's been convicted of federal crimes.
Whoops.
And possibly Chris Hines.
Look, if your main man is in the pen and he's got dirt on you, no, it's coming out. That dirt is coming out because you know how you get from the bad part of the pen to the good part of the pen? Give the government some juicy deets. Especially when the juicy deets are about their political opponent's progeny. That is a recipe for getting into the sweet country life. Prison. And do it in a heartbeat. Look, no more duct tape over your anus. You don't have to worry about that anymore because you just got to Club Med.
The
Club Med and the Fed.
Stepson of former Secretary of State John Kerry. And there's an arrangement to go under, I can't say 800 million, but a huge amount of money.
Huge. For
which they were paid a couple of $1 million up front. That's all I know. I don't know if it's true or not. I can find a few things on the hard drive that corroborate that, but I can't find like a memo yet. But I have to emphasize, I've only been through half of this hard drive.
Let me ask you about that, Rudy.
I don't buy that at all. Could you guys go through half of your hard drive in like a day? Oh, wait, no, he's had this for a while, hasn't he? He got this a little while back, and it's only coming out recently, I think. Okay, yeah. So he's had it for a little bit. Yeah, Muskie Mouse. I know about the Google suit. We'll talk about it soon. Now, I want to point out, like, this is Rudy Giuliani. I don't trust Rudy Giuliani at all. Like, not at face value. So I don't. I mean, the guy, you know, he did some good things in New York. He did some bad things in New York. He's a lawyer. He's a politician. I don't have any reason to specifically trust him. Not saying I distrust him necessarily, but I trust the evidence as it comes out. That's what I'm interested in. I'm not presenting this because I think Rudy Giuliani is some special saint, and I think that there's some issues with disclosing it to him, but who knows?
This is voluminous, and it already reveals about 5 major federal crimes and about $30 to $40 million that went to the Biden family as bribes to Vice President Biden.
All right.
Described by his son in the following language.
Okay, here's what we need.
I'll read it to you. This is, I don't receive any respect, and that's fine, I guess. Works for you, apparently. I hope all of you can do what I did and pay for everything for this entire family for 30 years. It's really hard, but don't worry. Unlike Pop, I won't make you give me half your salary. So basically...
Oh, Joe. Joe, are you taking your kid's money? What a turd.
Biden was using his son in a horrible way as a bag man. You would think he would get some kind of a political flunky to be his bad man, but instead, as his bag man, he used his son, who's afflicted with drug addiction. And over the period of years, he made the drug addiction much worse.
Very
having
unfortunate.
his son involved with some of the most crooked people in the world.
So, Mr. Mayor, a couple of things. Number one, the documents, the one that you just summarized, I read that in the paper. I also saw the email between Vadim Pazarsky and Hunter. Very interesting. Let me ask you this, though. Are there any documents, and I know there's a lot of things that you say document Hunter Biden's unusual sexual activities, but are there any documents, any more documents that tie Vice President Biden to Burisma or to money from Hunter Biden? I mean, let's face it, it's Biden, the father, who's on the ballot in 2 weeks. Anything else other than what we've seen so far tying him to Hunter's business?
Yeah, 2 major things that I found. In addition to this, which basically says that Biden was getting 50% of the bribe money, which makes sense, actually.
This is one
really
hell
very,
of an
very
October
sensitive
surprise if this is true.
There's a text message to his father in which he says the following, and he's discussing his sister-in-law, who for quite some time was his lover. And he says, she told my therapist that I was sexually inappropriate. This would be with a unnamed 14-year-old girl. When she says that I FaceTime naked with the unnamed 14-year-old girl, and the reason I can't have her out to see me.
Okay. I'm sorry. Can we fund the wall so that we can put Hunter on it?
Is because I'll walk around naked, smoking crack, talking tom girls on FaceTime. When she was pressed, she said that the unnamed 14-year-old girl never said anything like that, but the bottom line is that I created and caused a very unsafe environment for the kids. This is supported by numerous pictures of underage girls.
So, Mr. Mayor, that's dynamite stuff.
Woo! Whoop, 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 woo! Get him. Get him. FBI, open up. Get him. Get him. Who cares? Done. I don't care if Biden wins. Get Hunter out. Like, if he's got a bunch of pictures of kids. Now, Rudy didn't say they were nude pictures of kids. He did not say that. Remember, Rudy's a careful man. He is a lawyer. He did not say they were nude pictures of kids. He left us at the implication that they're inappropriate. But it literally could just be a bunch of pictures of kids, which would also be weird but not illegal. So yeah, look at that. Look at the disappointed dad face on Rudy Giuliani. Like, Hunter just came home and told me he got a D in physical education. Now I realize I have a girl. No, I'm just kidding. That was mean.
Stuff. and I've seen
I
it.
turned it over to the.
You turned it over to the Delaware State Police, correct?
Yes, yesterday. Bernie Kerrick and I turned it over to the Delaware State Police because we're very uncomfortable with this.
So
we're very uncomfortable with the fact that these underage girls were not protected.
So here's the deal. Hunter Biden, let's face it, he's never going to be elected to anything, and he'll probably wind up in jail someday for something. Who knows? But I'm more concerned about the vice president because he's the one who's running. Right, I see that. But you know what I don't see, Mr.
This was sent to the vice president.
Here's the deal. And look, I want to be clear here.
Sounds like him.
Oh, no. Wait, those are messages to Biden? He's contacting Biden on Messenger? Will someone teach these boomers how to use fucking Signal? What is wrong with these people?
Yeah, but you know what? It's not there.
Sent to him. What did he do about it?
Exactly.
What did he do about it?
Well,
for 3 years.
Mr. Mayor, the only thing is, in that, hold on a second, in the text messaging you just showed me and we went through, we've got Junior, who is Joe Biden, talking to Hunter Biden. We have no acknowledgement in what we just saw from the vice president. We don't know what he knows or whatever, and this is all family drama. And by the way, it's so late. It's big time. They could be in trouble. And I'm glad you got it out there. But I want to know: is there anything concrete tying Joe Biden to Burisma money from China? It does not look good at all to me. Those emails and what they were up to. Anything in that regard? And if you haven't found it yet, you're kind of saying it might still be there because how much of this hard drive have you been through?
I found it already. You found it. There's a memo in here that says that 10% of the money that was being whacked up, $10 million a year, and then 50% of the profits with 3 Chinese communists, one of whom was a Chinese intelligence operative, that 10% of that was going to H for the big guy. So we've identified the big guy several ways. One, right after that text message, email rather, there's an email that is asking for keys for the office they're going to share with the Chinese communists. And the first key they asked for is for Joe Biden, the big guy.
Yeah.
Number 2, there's an anonymous source that has told Fox News that the big guy is definitively Joe Biden. He's one of the people involved in the deal. I know his name. I'm not at liberty to tell you, but I'm told that within a day or two, he's going to go public.
I can't wait to hear the information when it's ready to go public. Mr. Mayor, a couple of quick things. The Attorney General, we know the president is kind of impatient.
This other guy is so loud.
I said, is he going to be around for a second term? He said no comment. Looks like this hard drive may have been in the FBI's possession for over a year at this point.
No, I think 7 months. Correct. Right.
7 months, to be fair. All right.
7 months.
At this
7
point,
months.
Is the Attorney General going to do anything before Election Day, as far as you know?
I have no idea. All I can tell you is, if you were to look at the photographs on this hard drive, and you didn't report it to the police, well, if you were a law enforcement officer, you'd be guilty of a felony. And if you're just a normal citizen, you'd be a horrible human being. There are numerous pictures here of girls that are being, they shouldn't be there. That's all I can tell you.
I understand.
And if the Delaware State Police don't do anything about this, it would be really a tragic thing.
So, Mr. Mayor, a couple of quick things. We don't have too much more time. Do you need help? I mean, I'm not a tech person. I know you're not a tech person.
He doesn't have it anymore.
I love you. We go way back. You've got a lot of detractors in the country. Everybody does.
Oh,
it's okay.
Sure. Yeah. Only because it's true.
Would you like any help at this point? Because one thing that I don't think is fair, quite frankly, to you, the media should have been helping and assisting in pursuing this themselves. They never did. They won't. They refuse to. I mean, and sometimes, Mr. Mayor, you're kind of, you're a lot to handle for them. Is there anybody else who could possibly help? Do you need help? Do you want help?
Yeah, sure, I want help. I mean, I've got half a hard drive to go through. Instead, I have an iron curtain that is trying to censor everything that's coming out. It's unprecedented. We've got, and it tells you how damaging this information is. I will tell you, Greg, this is probably the worst scandal I've ever seen. And there's a depravity to it that's horrendous, which is why I reported it to the Delaware police. and I hope they're independent enough to investigate it properly. But there are images on here.
Why don't you give it to the FBI?
You don't realize how
the FBI already
damaging
has
it
it,
is to
I
young
guess.
people. There's something wrong with you. And Joe Biden knows that. Plus, Joe Biden is the one who used his son to be a bag man for 20 years when he knew his son was a drug addict. This is not about Hunter Biden. It's about Joe Biden. It's about what a crook he is and what a horrible father he is.
Mr. Mayor, how about this? You've got the hard drive. Now, one thing that's different between how this is going down and, say, what happened to Hillary Clinton with WikiLeaks, I believe they made the data available. I mean, like they put a lot of it online so news organizations could access it. In this situation, we're kind of like, waiting for you.
You can't put some of this stuff online.
To kind of spoon feed us every now and then. Have you thought about just putting it all out there, whatever you can do legally?
Sure, I have, if I could find a news organization that's independent enough and willing to really deal with it honestly, as opposed to the iron curtain that I have of Twitter not being willing to put out.
Rudy, I'm your guy.
Facebook.
Send it to me.
New York Times, New York Post.
Ricada Media, Rudy. We got you. We got you, fam. I will turn the internet's autism onto it.
The Washington Post, NBC, ABC, CBS. There's an iron curtain of censorship over this. And I'm going to tell you why. Because this is fatal to Joe Biden as a candidate. It should be fatal to him as a human being, because I don't
Holy
fatal,
shit!
But I mean, he should be prosecuted. These are major bribes.
Rudy just called for the death of Joe Biden.
And there's a sexual depravity to this that is disgusting.
One of the reasons why they don't do it, the mainstream, and they should, they feel guilty over how they treated. They think they were unfair to Hillary Clinton in 2016 with those emails, and
she got away with major crimes.
Well, they're atoning, by the way. That's one of the reasons they don't want to do to Joe Biden. They think what they did to Hillary, they think that, and it's totally not fair. And we need to know. And by the way, last thing, it's indicative that this stuff has veracity, that Joe Biden has been in hiding, only went out for one ice cream, and then ran back to the basement, right? I mean, that's almost tantamount to a confession.
As a prosecutor, I will tell you, he hasn't denied a single text or email, nor has Hunter, nor have they denied that this
Trump
is
hammers
hard
him
drive.
on this on Thursday.
And this is
Imagine
5 days,
the fireworks.
6 days now. And there's no doubt this is his hard drive. And there's no doubt that the Biden family, over 30 years, in the words of him, Hunter Biden, made millions and millions of dollars, of which he had to give half to his father. That's the bribery scheme.
He should just answer every question starting with Hunter Biden.
And that's disgraceful. Joe Biden had a bunch of Washington flunkies who could have been his bag man, not his kid. If this kid has a bad crack problem, the reason is that his father put him in situations he shouldn't have been in.
Mr. Mayor?
Maybe even more disgraceful than the crimes he committed.
I think you're fighting the good fight, and I know that can be lonely, and I know you're taking it from all sides, but you're clearly onto something, and Joe Biden seems to be running scared. To be continued. America's
Listen
Mayor,
to this
Rudy
heroic
Giuliani,
music.
We appreciate it so much, okay?
Newsmax is great.
Thank you, Greg. God bless you.
You bet. All the best. All the best.
Newsmax TV is now America's fastest growing cable.
Whoa. Okay, that was loud. Biden got really tripped up. Got really tripped up by, accusations about Hunter on, He got, oh gosh. Look at this. Who is this? Oh, this is on, okay, this wasn't on my thing. I thought, Jesus. Sorry. Okay, here's the next thing I want to bring up. So this is from Catherine Herridge on Twitter from CBS News. It says, new law enforcement source tells CBS News that the FBI plus the DOJ concur with the Director of National Intelligence, Ratcliffe. The laptop and emails said to belong to Hunter Biden were not part of the Russian disinformation campaign, and the FBI has the laptop. Separate reporting suggests could be part of foreign influence op. So, if you remember, there was an alleged disinformation campaign about Joe Biden, that Russia was going to try and convince everyone that Joe Biden was crazy, incompetent, has Alzheimer's, or otherwise unfit for office. That would have been a waste of time and money, because again, you could just listen to Joe Biden and come to that conclusion. But the director of national intelligence has said that these emails and the laptop are not part of any disinformation campaign. That is about as close to authenticating them as they're probably going to come in a public statement at this point in time. So, this will be very, very interesting. And you should bet, because if he doesn't do it, he's a moron. Trump will be talking about this on Thursday. Trump will be talking about it on Thursday. And he should honestly just answer every question with, let's talk about Hunter, Joe. Let's talk about Hunter. Let's talk about him. Talk about his crack problem. How much money did you take from Hunter Biden over the years, Joe? Just do that over and over. Over and over. But even when Joe was asked one question at a town hall that didn't have Trump there, he freaked out on the one lady. You're talking about things you don't even understand. No evidence of. It's let him mute Trump's mic. Let him do it. Let him do that during his own time, because he brings up Hunter Biden. Let him do that and see how well that works. People will go crazy. It'll be a riot. It'll be a riot. They should definitely do. So that's this story. This is a big story. This is the October surprise. I think they were trying to make Trump's taxes the October surprise. That didn't really work. They don't seem to have an October surprise for Trump yet. I guess there's still a little bit of time left. Not sure what their strategy was. But with Giuliani having this for a long time, the FBI having this for 7 months, this clearly looks like an October surprise sort of thing to me. This is the one thing I want to caution everybody on, okay? I want to caution everybody on this because of the timing. We're in an election year. The fact that the FBI has held on to this for 7 months without action. Now, the FBI does just hold on to things. Like, that's not that uncommon. They have a several-year statute of limitations on things like child cheese pizza, and financial crimes could have 5-6 year statutes of limitations. Sure. So it's not that strange. However, it's also not strange for the FBI to move quickly on information like this. So I want to caution everybody in that it's possible that if the FBI had this information and didn't act, it's because it's not, in their opinion, criminal. It's possible. I'm not saying it is. Not saying it's fake news. I don't know. We only have part of the story. But if the FBI had this for 7 months, if anybody looked at it and didn't act on it, it might be because it's not unlawful. Now, Rudy strongly hints that it is unlawful, but he also has a motive to do so. He's the president's personal attorney, and he's also a big PR guy, and the president is trying to win an election. Very useful for the president to have this come out right now. So just take everything with a measure of pause. What they're saying is true. It's huge news. But they better act quick. They better act quick on it. Yeah, listen to Libertarian. Libertarianism has nothing to do with the idea that someone might try and distort facts during a political season. It's actually recognized Like, do you guys know that the Supreme Court has recognized politicians' ability to lie to the people, like as protected speech? Call it political puffery. It's a term that's been around forever. Like, they can lie about their opponent. They can outright defame them in many ways. And it's considered political puffery. It's a recognized Supreme Court decision about it. So, like, just, again, it doesn't have anything to do with any political beliefs. Right now, it looks very credible. The Director of National Intelligence is talking about it. But, you know, just be cautious. Always be cautious. I hope they move on it. If this guy has pictures of, like, kids on his computer, put him in prison forever. Forever. If Joe Biden was doing some sort of illegal scheme to get a bunch of money and launder money for people in Russia and Ukraine or whatever, put him in prison forever. Forever. Please, just do it. That's all I want. That's all I want. In the meanwhile, let's hope they act prior to the election. They should. If they have the info, they should do it. So that's that. That's that. Mr. Schwagen says the real question is, why didn't the FBI bring up this laptop during the impeachment? They've had it for 1 year, for over a year. Delaware is a small state, and the Bidens are big fish. Friends helping friends between the field office and them. Who knows? It's hard to say. Like, there's all sorts of reasons. There are all sorts of legitimate reasons that the FBI might not have looked through the laptop. Might not have thoroughly looked through the laptop. Might have just gone into a storage locker somewhere. Who knows? Who knows? God says the real surprise was the Biden-Hunter Ukraine issue was public knowledge since before 2014. There you go. There you go. Okay, well, I'm running way behind on this. Let's do this DragonLance lawsuit. This is very, very big stuff. We're gonna skip through parts of it to hopefully get through it. Oh, and then after this, we're gonna watch. We've got 2 movies to watch tonight on Twitch. One is House of a Thousand Corpses, which is the first movie I did a watch party for. Many of you who joined me for the watch parties weren't there for that one, I don't believe. And it's October. It's horror month. It's one of my favorite horror movies, so that's why we're doing it. And the next movie is called The Church. I read the synopsis, and it seems like a winner. I'll read it to you real quick. All right? An old Gothic cathedral built over a mass grave develops strange powers which trap a number of people inside with ghosts from a 12th century massacre seeking to resurrect an ancient demon from the bowels of the earth. I don't know what could be better than that. It sounds great. All right, so House of a Thousand Corpses followed by The Church. Nice little bit of Satan, little bit of God. That's what we're doing. Okay. Let's hit this. This is Margaret Weiss and Tracy Hickman suing Wizards of the Coast. Wizards of the Coast being the owners of Dungeons and Dragons. All right. Nature of the action. Margaret Weiss and Tracy Hickman, collectively, the plaintiff creators, are among the most widely read and successful living authors and world creators in the fantasy fiction arena. Over 35 years ago, plaintiff creators conceived of and created the Dragonlance universe, campaign setting for the Dungeons & Dragons role-playing game, the rights to which are owned by defendant. In Dungeons & Dragons, gamers assume roles within a storyline and embark on a series of adventures, a campaign in the context of a particular campaign setting. Plaintiff creators' conception and development of the Dragonlance universe has given rise to, among other things, gaming modules, video games, merchandise, comic books, films, and a series of books set in the Dungeons & Dragons fantasy world. While other authors have been invited to participate in creating over 190 separate fictional works within the Dragonlance universe, often with plaintiff creators as editors, Weiss's and Hickman's own works remain by far the most familiar and saleable. Their work has inspired generations of gamers, rise up, readers, and enthusiasts, beginning in 1984 when they published their groundbreaking novel, Dragons of Autumn Twilight, which launched the Dragonlance Chronicles trilogy. Their books have sold more than 30 million copies. And their Dragonlance World of Krynn is arguably the most successful and popular world in shared fiction, rivaled in the fantasy realm only by the renowned works created by J.R.R. Tolkien, which do not involve a shared fictional world. Now, am I wrong in thinking that the Forgotten Realms has become more popular than Dragonlance? Maybe I am. Or is Forgotten Realms not a shared fictional world? Within the Dragonlance universe, Plaintiff creators have authored or edited 31 separate books, short story anthologies, game materials, and art and reference books in a related series of works, all dedicated to furthering the D&D Dragonlance branch. Realms aren't as popular as Dragonlance? That's crazy to me. In or around 2017, plaintiff creators learned that Defendant was receptive to licensing its properties with established authors to revitalize the D&D brand. After a 10-year hiatus, plaintiff creators approached Defendant and began negotiating for a license to author a new Dragonlance trilogy. Plaintiff creators viewed the new trilogy as the capstone to their life's work and as an offering to their multitude of fans who had clamored for a continuation of the series. Given that the Dragonlance series' intellectual property is owned by Defendant, there could be no publication without a license. In March 2019, the negotiations between the parties hereto culminated in a new written licensing agreement whereby Weiss and Hickman were to personally author and publish a new Dragonlance trilogy in conjunction with Penguin Random House, highly prestigious book publisher. By the time the license agreement was signed, Defendant had a full overview of the story and story arc. This is going to help us skip a big section of the lawsuit, by the way, with considerable detail of the planned trilogy. Defendant knew exactly the nature of the work it was going to receive and had pre-approved Penguin Random House as a publisher. Indeed, Defendant was at all times aware of the contract between Penguin Random House and plaintiff creators, the publishing agreement and its terms. In fact, the license agreement expressly refers to the publishing agreement. By June 2019, Defendant received and approved a full outline of the first contracted book in the trilogy, Book 1, and by November 2019, the publisher accepted a manuscript for Book 1. Plaintiff creators, in turn, sent Book 1 manuscript to Defendant, who approved it in January 2020. In the meantime, Defendant was already approving foreign translation rights and encouraging plaintiff creators to work on the subsequent novels. Weiss is pronounced like ice. Weiss. Okay, got it. During the development and writing process, plaintiff creators met all contractual milestones and received all requisite approvals from Defendant. Defendant at all times knew that Hickman and Weiss had devoted their full attention and time commitment to completing Book 1 and the trilogy as a whole in conformity with their contractual obligations. This is important because this is them foregoing other work or other projects in favor of this contract, which comes into play in damages. During the writing process, Defendant proposed certain changes in keeping with the modern-day zeitgeist. There you go. Wizards of the Coast proposed certain changes in keeping with the modern-day zeitgeist of a more inclusive and diverse story world. Oh, thank you. Thank you, Wizards of the Coast, for making a game with like 50 different races somehow more diverse. Thank you. Thank you for making orcs into black people. At each step, plaintiff creators timely accommodated such requests and all others within the framework of their novels. This collaborative process tracks with Section 2A3 of the license agreement, which requires Defendant to approve plaintiff creators' drafts or, alternatively, provide written directions as to changes that will result in Defendant's approval of a draft. And that's a very important thing as well that they'll get to in more detail in a little bit. On or about August 13th, 2020, Defendant participated in a telephone conference with plaintiff creators' agents, which was attended by Defendant's highest level executives and attorneys, as well as Random House executives and counsel. At that meeting, Defendant declared that it would not approve any further drafts of Book 1 or any subsequent works in the trilogy, effectively repudiating and terminating the license agreement. No reason was provided for the termination. In any event, no material breaches or defaults were indicated or existed upon which to predicate the termination. Termination was wholly arbitrary and without contractual basis. The termination was unlawful and in violation of multiple aspects of the license agreement, arguably almost every part of it, in fact. The termination also had the knowing and premeditated effect of precluding publication and destroying the value of plaintiff creators' work, not to mention their publishing deal with Penguin Random House. Okay, so It's important because if they don't approve the drafts, then the creators cannot publish the work because they don't own it. So the licensing agreement requires approval from Wizards of the Coast. Wizards of the Coast refuses to approve it. They can't ever publish it. And therefore, we have two issues now. Breach of contract, and we have tortious interference with contract. And that is the Penguin Random House publishing agreement that they had can't be fulfilled if they can't publish the work. So you have Wizards of the Coast. They've laid out that Wizards was aware of the Random House, the Penguin Random House agreement. They knew about it, and they knew that preventing them from being able to publish anything would similarly breach that publishing agreement. It would make the contract inoperable, incompletable, and therefore that would be tortious interference. So we have tortious interference. We have breach of contract. There's another cause of action, and it's specific to some states, including the state of Washington. This is filed in federal court, but in Washington state. And it's under Washington state contract law because that's where Wizards of the Coast is located and headquartered. And it is what's called, and this is the big one, y'all. And I really want to get a short video out on this tomorrow so this can be shared around. This is what makes this really dangerous for Wizards of the Coast. Washington state, along with several other states, have something called an implied duty of good faith and fair dealing in contract law. That means that every contract that is signed and under Washington state law, the parties have a duty of good faith and fair dealing. It means they have a duty to cooperate to make the mutual benefits of the contract manifest. All right? So if you don't have a duty of good faith and fair dealing in your state automatically, and you don't write it into the contract, then the other person can be kind of lazy in their perform. Like they can perform, but they don't have like an affirmative duty to make the contract work. They can let the other person make the contract work. In Washington, where this contract is located, they have a duty to try and make it work. Wizards of the Coast can't just say, we're not going to approve anymore. That's a separate cause of action, and it is probably what's going to really hammer the nail in here, and it eliminates a lot of their avenues for defense because they have to try and make it work by law. And if you know contract attorneys, they love finding an implied duty of good faith and fair dealing, or an express one. Defendants' acts and failures to act breached the license agreement and were made in stunning and brazen bad faith. Defendant acted with full knowledge that its unilateral decision would not only interfere with, but also would lay waste to the years of work that plaintiff creators had to that point put into the project. Given that the obligation to obtain a publisher was part and parcel of the license agreement, defendant is fully cognizant that its backdoor termination of the license agreement would nullify the millions of dollars in remuneration to which plaintiff creators were entitled for their publishing contract. As they subsequently learned, defendant's arbitrary decision to terminate the license agreement and thereby the book publishing contract was based on events that had nothing to do with either the work or plaintiff creators. In fact, at nearly the exact point in time of the termination, defendant was embroiled in a series of embarrassing public disputes whereby its non-DragonLance publications were excoriated for racism and sexism. Moreover, the company itself was vilified by well-publicized allegations of misogyny and racist hiring and employment practices by and with respect to artisan employees unrelated to DragonLance. Plaintiff creators are informed and believe, and based thereon allege, that a decision was made jointly by defendant and its parent company Hasbro to deflect any possible criticism or further public outcry regarding defendant's other properties by effectively killing the DragonLance deal with plaintiff creators. The upshot of that was to inflict knowing, malicious, and oppressive harm to plaintiff creators and to interfere with their third-party contractual obligations, all to plaintiff creators' severe detriment and distress. Okay, so part of their theory here is they're getting hammered on all this inclusivity crap, and they want to shuffle that off by killing the DragonLance deal. Now, I don't know the plaintiffs, but I have heard that they're not too keen on the woke stuff. I've heard they're not too keen on it myself. Maybe you guys know more. So we've got facts. This is the background stuff. This isn't really super important. They set it all up. Let's get to some interesting stuff here. On or about February 28th, 2019, defendant and Random House, technically Del Rey Books, an imprint of Random House Publishing Group, which is a division of Penguin Random House, entered into a side agreement that was essentially a building block for the final license agreement. In that side agreement, defendant not only specifically acknowledged Random House's pivotal role in the licensing arrangement with plaintiff creators, but also expressly made clear that the license was going to be conveyed in toto to plaintiff creators, with only a few stipulations as to ownership of the underlying intellectual property to Dungeons & Dragons DragonLance, and with very limited approval and consultation rights reserved to defendant, all of which related to marketing of the books, book jacket art, press releases, advertising copy, author tour, and certain facets of a potential digital ebook edition. Each of the parties, including Random House, recognized that in the context of producing the trilogy, a license or licensing agreement that could be retracted arbitrarily at the whim of defendant or its corporate parent would be illusory and ineffective. In any case, it would hardly be the basis for either plaintiff creators or the publisher, any publisher in fact, to move forward with a transaction. To the contrary, the whole point of the contemplated set of agreements was to give all parties, including Random House, assurances that the license was in place and the contractual predicates were set in stone so that the project could be completed. This is what I was talking about earlier. They're setting it up. It's a 3-book deal. They know the books are going to get made. They know they're going to have the ability to publish the books. It's the promise for everybody. It's how you make a small deal into a big deal. The negotiations conclude. Here we go. Accordingly, certain milestones were set whereby defendant, having approved the story concept, storyline, and story arc, reserved the right to approve certain narrowly defined deliverables, primarily limited to the marketing of the work. The approvals were never meant to be a replacement for the express and narrow termination provisions of the agreement, which we'll get to in a little bit. Here we go. In November 2019, Random House indicated that the complete manuscript of Book 1 was accepted and it would push through the second payment due to the publishing agreement. At that time, plaintiff creators submitted the complete manuscript of Book 1 to defendant Hasbro, who expressly approved the Book 1 manuscript in January 2020. Inexplicably, and despite plaintiff creators' repeated requests, Random House never actually delivered the second payment due on approval of the Book 1 manuscript. In compliance with the license agreement, drafts of Book 1 manuscript were shared and approved by defendant. In fact, on January 21st, 2020, defendant, through the Hasbro Property Group approval system, specifically approved Book 1 manuscript by a written approval number 272074-0. Book 1 was now provisionally identified and named Dragons of Deceit. By late 2019, plaintiff creators had also completed substantial work on the Book 2 manuscript. Relatedly, by December 2019, Random House had negotiated a German translation deal for plaintiff creators' works. At each phase of the activities, plaintiff creators obtained separate approvals from defendant through the Hasbro Property Group approval system, and with defendant's knowledge, transmitted those approvals to Random House at all times relevant to here too. So they're laying out a very consistent story. They knew every step of the way exactly where the books were. They were approving them. They were giving feedback. They were saying everything was good and encouraging more work. All right. In or about June 2020, defendant changed the editorial and oversight team assigned to the new Dragonlance trilogy, removing Liz Shue and Hillary Ross and replacing them with Nick Kelman and Paul Morrissey. Do you guys know anything about Nick Kelman or Paul Morrissey? Mr. Kelman, who was and remains defendant's head of story and entertainment, was a controversial choice. As recently as 2019, his own publication as author of the sexually explicit novel Girls, A Pain, was subject to ongoing public discussions of whether his work contained or promoted misogyny and pedophilia. Okay. The Medium article itself contains trigger warnings of implied sexual abuse and statutory rape. Following Mr. Kelman's assignment to defendant's Dragonlance team, defendant issued a 4-point set of comments dealing with various sensitivity issues, ranging from the use of love potions in the story. Though after Bill Cosby, you can't have love potions in a fantasy story unless you call them a hot Cosby. You can call the love potion a hot Cosby, and then it's good. But if you don't call it a hot Cosby, you can't. As referenced in the 5th edition Dungeon Master's Guide, the concerns of sexism, inclusivity, and potential negative connotations of certain character names. On each occasion, when the publisher or defendant directly or indirectly expressed reservations about the text or requested rewrites, including sensitivity rewrites, plaintiff creators accommodated such requests and provided rewrites, in one case, 70 pages worth. Regardless, at no point in time was there any indication of any problem with the writing or rewriting process. In fact, given that the process was moving forward, plaintiff creators also informed defendant that they had completed book 2 of the trilogy, provisionally titled Dragons of Fate. So they're getting woke directions on the fly. That's what's going on here. And they're having to wokeify their books a little bit. Too much sexism. Too much manliness happening in Dragonlance. Love potions are verboten. Probably warriors with 18/100 strength like Caramon can't have those around anymore. Who knows? Who knows what the actual changes were? Now, they're indicating in the language that not all of the rewrites are sensitivity rewrites, only that there might be some. Too many lances. Look, on page 112, you say that the lance penetrates the dragon. We need you to remove penetrates from the work entirely. Please never say it again. By early to mid 2020, particularly in the July 2020 timeframe, separate from anything having to do with Dragonlance, defendant was engulfed in controversies. Specifically, defendant was subject to a drumbeat of negative publicity related to alleged pervasive racism and various forms of cultural insensitivity and offensiveness in connection with its Magic the Gathering trading cards. Remember when they got rid of the White Crusade card? That's too racist now? No more Deus Vult? As well as with its professional hiring and advancement practices within the company. In particular, beyond the issue of Mr. Kelman, who remained controversial, the hiring of alleged white supremacist, alt-right, QAnon-affiliated story artist Therese Nielsen was targeted by defendants' detractors, as was alleged over-sexualization of the work by content creator Elizabeth Eden. Okay? I don't know anything about Therese Nielsen or Elizabeth Eden, but I know her name is Lizbeth, and that's annoying. Further, certain allegations made against defendant by defendant's former employee, Orion Black, a self-described non-binary black person, became a media sensation. As a result, defendant issued a public apology, which in turn only fanned the flames of consumer Twitter internet blowback against defendant all the more. On information and belief, the aforementioned controversies came to the attention of and were addressed at the highest levels by defendant's parent company, Hasbro. Plaintiff creators ultimately discovered that at the same time defendant was under public siege, defendant was interacting and communicating directly with Random House on editorial topics related to Book 1 and the trilogy with the intent of actively interfering with plaintiff creators' business relationships. Here we have some evidence of the tortious interference. Random House does not have a contract with Wizards of the Coast. They have a contract with Weiss and Hickman. So for Wizards to reach out to Random House and discuss the books, to discuss the contractual arrangement between Random House and Weiss and Hickman, might be improper if it interferes with it. All right. On or about August 13th, 2020, acting with the knowledge and consent and possibly at the direction of Hasbro, defendant held a telephonic meeting with plaintiff creators and their representatives. Now, they don't have the information right now to add Hasbro in. They want to. They're dropping hints that Hasbro might have had a hand in this. The reason they're doing that is because Hasbro is a multi-billion-dollar company, whereas Wizards is in the hundreds of millions. It's always better to target the multi-billion-dollar company, especially if you're able to get any sort of punitive damages or anything like that. So they're dropping hints that Hasbro may be in here. They're laying the foundation for it, where if they happen to catch something in discovery that indicates Hasbro can be brought in, they'll do it very quickly. It's also, I would suggest, a warning shot to Hasbro. Saying, hey, maybe you want to tell Wizards to knock this shit off. Publish the books. That's how they solve this, by the way. This is how Wizards solves this, really simply. We're going to publish the books. We're going to just, we'll give you the license agreement. Let's publish the books. Let's finish the books. That's how Wizards solves this problem immediately. We're going to stop making these editorial decisions. We'll give you more creative freedom. Publish the books. Please stop suing us. And that's what I think this lawsuit is intended to garner. I don't think they want this to go all the way. I think they want to force the publication because that's how everybody makes money. The fans are happy. The writers are happy. And everybody just gets to do it. We'll see. We'll see what happens, though. Among those present at the meeting were Messrs. Kelman and Morrissey, defendants' in-house lawyers Nick Mitchell and Ben Hellerstein, and various Random House representatives, including executives and counsel. At that telephonic meeting, without any forewarning, defendant's attorney, Mr. Mitchell, stated defendant refused to perform under the license agreement, effectively terminating the agreement unilaterally. When challenged about the grounds for such termination, Mr. Mitchell responded with a nonsensical statement, quote, "We are not moving toward breach, but we will not approve any further drafts." That is breach. That is breach. Defendant's statements and conduct were a stunningly bad faith effort to circumvent the termination provision of the agreement by expressly withdrawing its future approvals. Defendant effectively terminated plaintiff creators' ability to publish their work, destroyed plaintiff creators' ability to mitigate or modify their storylines or marketing materials to address any approval issues, which we'll find out is in the license agreement that they're supposed to do that, and knowingly interfered with plaintiff creators' third-party contracts with Random House, resulting in the loss of not only the guaranteed advance, but royalties, incentive payments, and the exploitation of the sub-licensing rights of the licensed property that would easily eclipse the guaranteed advance, depriving plaintiffs of millions of dollars over the terms of the license agreement. As will be the subject to proof at trial, defendants' acts were not privileged under the agreement and are not subject to any of the contractual limitations on damages. Further, defendants' conduct, alone or in conspiracy with Hasbro with respect to Random House, was conducted with malicious and oppressive intent for the sole purpose of silencing and harming plaintiff creators. That is punitive damages. That is punitive damages. That's what they're doing here. Such acts were for corporate reasons that, on information belief, had to do with defendants and Hasbro's public relations disasters with respect to defendants' workplace management and intellectual properties unrelated to the DragonLance trilogy, for which plaintiff creators endeavored over so many years to create, complete, and bring to fruition on behalf of their eager readership. All right. So the first, breach of contract specific performance. Okay. This is the first claim for relief. Very important. They entered into a valid binding contract on or about March 21st, 2019. Contract is identified above as a license agreement. Defendants, in entering into the license agreement with plaintiff creators, granted plaintiff creators a, quote, non-exclusive right to use, copy, prepare derivative works of, display, perform, and distribute the property, DragonLance, solely for the purpose of development, publication, distribution, and sale of the works, defined in the key terms as the new trilogy. So they could create the new trilogy and derivative works of the new trilogy for the purpose of selling the new trilogy. Okay, does that make sense? The existence and centrality of the Random House contract to the license agreement was baked into the license agreement. To this end, the license agreement provided plaintiff creators with an exclusive sublicense with respect to publication. Specifically, defendant agreed that, quote, licensor grants to licensees, that's Wizards of the Coast, to the plaintiffs, an exclusive right to sublicense the property as used in the works to publishers. Notwithstanding anything herein to the contrary, licensor has approved of Penguin Random House. So in the license agreement, they've already approved of Random House as a publisher of the works and agrees that licensees can sublicense the licensed property to Random House for the term in this agreement or until the agreement between licensee and Random House has expired or terminated. So that's section 1A2. All right. So again, this is a very well drafted complaint. I want to point that out. They're hitting the major points. They're pointing to the exact provisions of the contract where this stuff takes place. They're letting the court know and the other party know, you guys agreed to all of this in advance. You agreed to this. You knew about all of this. We know you knew about it. And acting contrary to that is going to get you in a lot of trouble. Given the license term is set forth in the key agreement, stipulates a 10-year term, the Random House contract that mirrors that provision has not expired or terminated. Nowhere in the license agreement did defendant assert, stipulate, or contend that it is granting a revocable license other than with respect to the 10-year term. Specifically, in the key term sheet, defendant made clear that the 10-year term commenced from the first sale of the third book and expired 10 years later or by December 31st, 2032, whichever was first. License agreement Exhibit A, thereto, key terms. The obligations under the license agreement are clearly set forth in Section 2 of the agreement itself. Specifically, plaintiff creators were obligated to set the work in the DragonLance campaign setting, use good faith to develop and publish at least one work per year, secure a publishing deal, and comply with a few other marketing responsibilities. License agreement Section 2A, 1 through 2, and 4 through 7. Significantly, Section 2A3 provides that, quote, licensees shall submit drafts of each work to licensor for review and approval prior to publication, within a mutually agreed time period not to exceed 10 days following receipt of such draft. Licensor shall respond in writing to licensees, advising licensees whether such draft is acceptable to licensor. So they have an affirmative duty. I know you guys are making fun of me every time I say duty, but an affirmative duty. They must respond within 10 days. Shall is a commanding statement in contract law. So within 10 days, they must approve or tell them if it's not acceptable, advising the licensees in reasonable detail of the changes necessary in order to make it acceptable to the licensor. So they have to either approve it, or if they don't approve it, they have to say what they don't approve. This is really, really important. And this is identifying veteran book writers who are high value, who produce works that will sell, probably well represented in these negotiations, hammering out a license agreement that is protecting them. This license agreement is protecting the creators. And a good licensing agreement will do that. It will protect both parties. But if this is a first-time writer, like a Marvel writer, you think Marvel writers have like good provisions in their agreements? All right. Nothing in the above provision allows defendant to terminate the license agreement based on defendant's failure to provide approval. To the contrary, should defendant find any aspect of the draft to be unacceptable, defendant has an affirmative duty under contract to provide reasonable detail of any changes plaintiff creators must make, which changes will result in defendant's approval of the manuscript. Accordingly, for defendant to make the blanket statement that it will never approve any drafts going forward is by itself a breach of the license agreement. And it is. And it is. Section 2B in the license agreement itemizes two significant obligations on the part of the defendant. Specifically, this subsection provides that licensors shall provide licensees with story guides for use in the development of the works, and licensors shall provide a reasonable amount of consultation to licensees throughout the development of the work. License agreement at 2B. Having summarily announced that it would no longer approve any drafts, defendant separately violated and breaches Section 2B of the license agreement. Section 3 of the license agreement separately obligated defendant to provide specific approvals of various aspects of the works. Section 3 does not supersede the draft approval process in Section 2A3. To this end, Section 3 provides, quote, anytime I say quote, that means this is important, it's from the text. Details related to each of the work's development plan, publication, sales, and marketing, including schedules, milestones, localizations, advertising, and marketing materials, each marketing plan, websites, promotions, publishers, and other matters reasonably requiring approval are also subject to licensor's approval. Notwithstanding anything provided in this agreement to the contrary, any approval by licensor shall not be unreasonably withheld, delayed, or conditioned, with the understanding that if licensor fails to approve a matter or item, such non-approval shall be deemed reasonable. Licensor will approve or disapprove all submissions within 10 days of receipt. License agreement at 3. This provision limits the arguably illusory reasonableness factors to the enumerated items and makes clear there is a submission process that must be followed, and there is no basis to assert that all submissions will be rejected out of hand. Again, this constitutes a separate breach. The breach is further put into focus in terms of Section 3B and 3C. Tellingly, the draft approval process is excluded from Section 3A because it's in Section 2A3, and Section 3C makes it clear that there is a resubmission process in any event. Defendant statements and acts have rendered any further performance via submission, resubmission, or revision by plaintiff creators futile, has breached and frustrated the purpose of the license agreement. Defendant is in further and separate breach of the contract because it has terminated the contract outside the termination provisions as set forth in Section 9 of the license agreement. These sections are really, really important. That's why we're going through them. These are the parts of the contract that they're saying are specifically broken, right? There are essentially 6 grounds for termination, none of which apply to defendant's conduct. Section 9 states in pertinent part, if licensees materially breach this agreement, and such breach is not cured within 30 days of the receipt by licensees of written notice thereof, licensor shall have a right to terminate. That means if Weiss and Hicks did breach the contract, the licensor must notify them of the breach, and they have 30 days to cure the breach. Not all breaches can be cured, but if it's curable, they have 30 days. They've never been given written notice of a breach, so that can't be it. So Wizards can't say, well, they failed to perform. They breached the contract because they haven't provided them a written notice of breach at this point in time. Let's see, where are we? Then licensor shall have a right to terminate. Licensor may also terminate upon written notice upon the occurrence of the following events, each of which is a default. 1. A licensee fails to comply with the approval or quality requirements. 2. The works do not comply with the applicable laws or regulations. 3. That'd be if you put cheese pizza in it. 3. Licensees sell or cause to sell one or more of the works outside of the licensed channel of distribution. So if they set up with a sub-publisher or something. Or 4. Licensees' repeated failure to affix proper copyright and trademark notices. And that's the license agreement in Section 9. So as long as you do these things, you can't terminate your agreement. There's an additional non-enumerated termination provision in Section 9 that allows termination, quote, if licensees fail to make a payment or furnish a statement in accordance herewith and fails to remedy such failure within 30 days of written notice thereof. So again, that'd be another breach where they'd have 30 days notice. Clearly, because this is a license agreement upon which a known third party publishing rights depend, the grounds for termination were purposefully narrow. And again, like I said, they were likely well represented in negotiating this out. These are high-value authors and probably had a lot of leverage. None of the termination provisions were triggered. I'm triggered. Nor was there a claim of material breach, much less written notice thereof, nor was a 30-day cure period initiated. While it is clear that for reasons of its own, defendant wished to terminate the license agreement, it could not do so under Section 9. Instead, acting in complete and stunning bad faith, defendant repudiated the license agreement by simply announcing that they would never approve any further drafts, and in fact, did not approve the actual draft that was pending. That said, defendant did not provide any cause for its non-approval, reasonable or not, and certainly provided no opportunity to address or cure the cause of non-approval, as is required by contract, thereby creating yet another express breach of contract. plaintiffs fully performed all acts required of them under the terms of the license agreement, with the exception of those acts excused by defendant's conduct. On or about August 13th, via the statement and action set forth above, defendant breached license agreement by, we already covered this, termination isn't in the termination provision. So they're subjecting an amount to be established at trial in excess of $10 million. So they're suing for over $10 million. Now here's the nasty kicker. Breach of implied duty of good faith and fair dealing. And again, these are in some states. Not all states have this. And importantly, if your state doesn't have this, you should be writing in an express duty of good faith and fair dealing, unless your party doesn't intend to uphold the contract well. In excess of $10 million. In excess. The license agreement between plaintiff creators and defendant contained an implied covenant of good faith and fair dealing by and between the parties, which prohibits them from engaging in any activity or conduct which would prevent the other party from receiving the benefits of the contract. Plaintiff have fully performed all covenants, conditions, and obligations required to be performed by reason of the contract, except to the extent waived, excused, or made impossible by defendant's breach of contract. Defendant, in acting or failing to act as set forth above, breached the implied covenant of good faith and fair dealing. In particular, but without limitation, defendant's backdoor termination of the license agreement on the pretext of we will not approve any further drafts was a stunning act of bad faith that completely destroyed the value, purpose, and protections of the agreement. There's no small irony that most of the terms that defendant unilaterally jettisoned, such as inter alia, among other things, the approvals provision and the termination provision, were terms that defendant itself had insisted upon including in the licensing agreement during the negotiation process. So what they're doing here is they're laying out the bad faith even further. Defendant wanted these terms. Defendant negotiated these terms in. These are from defendant, and then they breached it. That's bad faith. That's bad faith. Not only was defendant's statement that, quote, we will not approve any future drafts, a clumsy effort to circumvent the termination provisions, because of course there was no ground for termination, it undermined the fundamental structure of the contractual relationship whereby the defendant licensor would provide plaintiff creators the opportunity and roadmap to fix, rewrite, cure any valid concerns related to the protection of the Dungeons & Dragons brand with respect to approvals. In any event, defendant had already approved the essential storylines, plots, characters, creatures, and lore for the new Dragonlance trilogy when it approved plaintiff creators' previous drafts and story arc, which are complete unto themselves, were delivered prior to the execution of the license agreement and are acknowledged in the text of the license agreement. So they already approved a bunch of this stuff because they had done it before. Because Dragonlance isn't changing, right? There's not a dramatic shift in the background lore, is what they're saying. In other words, defendant's breach had nothing to do with plaintiff creators' work. It was driven by defendant's response to its own unrelated corporate public relations problems, possibly encouraged or enacted by its corporate parent, Hasbro. More bad faith right here. Defendant's backdoor termination also had the effect, which was fully known and intended by defendant, of destroying the value of the painstaking work that plaintiff creators had performed over the course of years in preparing and writing the works. Defendant was aware that Book 1 was basically complete and that Book 2 was substantially in progress. The story arc of Book 3 was in place from the beginning. Additionally, defendant's acts of bad faith nullified every effort the plaintiff creators had undertaken to enact the suggested, really mandatory, notes and direction issued by defendants along the way with respect to textual, conceptual revisions to Book 1. Now notice this. This is kind of funny. So on the surface, this sentence says that the defendants undid the work that the plaintiffs had to do, right? The plaintiffs had to go back and do rework because the defendants asked for it. And by terminating the contract without publishing anything, they've undone what the plaintiffs had to go back and do, right? But notice this little bit. The suggested, really mandatory notes and direction issued by the defendant. I don't think that these authors are too keen on being told to wokeify the Dragonlance books. I don't think they're down with it. I don't know him. Dan Willis says that Tracy is a personal friend, written a book with him. He's wanted to do this for years. He should force Wizards of the Coast to give up the license. Maybe Dan knows better, but I would suggest that maybe they're not down with the wokeness. They don't seem too happy with it. Further, defendant's bad faith conduct of knowingly, maliciously, and intentionally pulling the license and terminating the license agreement had the effect of interfering with and destroying the value of plaintiff creator's lucrative book deal with Random House, of which deal defendant was cognizant all along. Excess of $10 million. And then, of course, we have tortious interference. This will be based on the alleged conversation. You wizards get up, come on, get down with the wokeness. Is that what it is? Ooh, At all relevant times, defendant was aware of the publishing agreement and its terms. Defendant approved a draft of the publishing agreement. In the license agreement, defendant pre-approved Random House as a publisher under the license agreement, and the license agreement expressly refers to publishing agreement as being attached thereto. License agreement in Section 3, licensor acknowledges receipt of the synopsis and treatment provided by licensee that is the basis for having secured the attached agreement with publisher. Defendant intentionally caused plaintiff creators to breach the publishing agreement by preemptively refusing to provide any further approvals of the plaintiff creators' DragonLance work, which approvals are necessary for them to perform under the publishing agreement. On information belief, defendant also engaged in back-channel activities to disrupt the publishing agreement by convincing Random House that defendant would prevent plaintiff creators from performing under the publishing agreement. Okay, so that's going back to they don't understand why they never got their first book advance. They never got their first book advance, and that's very, very important. They mentioned that they allege that Wizards of the Coast is contacting Random House and that they inexplicably didn't get their contractually required first book advance. That would be the underlying allegation would be that Wizards of the Coast indicated to Random House that they were not going to move forward with the book and therefore not to send out the payment because they were going to breach the contract. All right. Okay, so prayer for relief, breach of contract, for damages, for interest on the sum awarded, for an order enjoining defendant to specifically perform under the license agreement by providing approval or instructions for revisions that will obtain defendant's approval for publications. So they're asking the court to give them money, give them interest on the money, and to force Wizards of the Coast to publish the book. Good call. Good call. God says the best part of getting woke is idiots going broke. There you go. That's for you. There's your Folgers woke broke ad for you. On the second claim for breach of covenant of good faith and fair dealing, all damages including actual, consequential, incidental, according to proof at trial, and for an order forcing them to perform they've got to perform it. And on the third claim for TI, all damages and for costs of suit incurred herein and attorney's fees, which are specifically allowable per contract, and for such other and further relief as the court deems just and proper. So that's what the specific performance is, Dabster. It is them demanding to have enforcement of the license agreement. So there you go, guys. That's the Wizards of the Coast lawsuit here. We're not going to do the Scalia segment tonight. We'll push it to tomorrow or something. That's the Wizards of the Coast lawsuit. It's a really well-drafted document. The claims are actually very sound based on its writing. There's no like, oh, maybe not. No. I mean, if you take this document at face value, they win. And they should. All right. If you take the document at face value, they win. Of course, Wizards will respond one way or another, and we'll get a different factual picture there. The problem that Wizards seems to have is unless there's some language that we're missing, they never communicated to them any sort of problem with the work. And if they never communicated a problem with the work, they likely didn't have a right to terminate the agreement or just decide to not perform on the agreement. This is a little different than other things. So, if you guys are familiar with publishing, writing, producing, one thing big companies do is they find a story that they like and they buy the option. All right. So they go, okay, we're going to buy a 10-year option on this property. And in that 10 years, at any point, they can execute the option. And in that case, they will create a work. They'll create like a movie, right? Or a graphic novel or whatever it may be. They're going to pay for the option, pay for the story, the rights to the story for a period of time. It's similar to a license agreement, but it's a little bit different. That's them giving the copyright owner money to prevent them from otherwise executing. They're buying an option to execute the right at any time. A license agreement works a little bit differently. Because a license agreement is a license to produce the work through someone else, the money making is done with the help generally of a third party or through additional work yourself, self-publication or a publisher. So in an option scenario, here's what would happen. I write a cool fantasy story, right? Wizards of the Coast approaches me and say, whoa, we really like your fantasy story. We'd like to buy the option to that fantasy story and maybe incorporate it into one of our properties. Then the next Magic the Gathering expansion set is based in the fictional world that I created. That's how that would work. They would be the ones exercising the option and therefore creating the work. Now, I would give them a license under the option in the same way to do that. But in the other way, the way that this one works, Wizards of the Coast is the property holder, and they're giving the license to someone else to make someone else go do the work that they would, leave to a more competent person. It's a little bit different. It's giving rather than asking. And when you give that out, that person is now to go somewhere else to actually create the product, in this case, Random House. So you've got a separate contractual issue at play. So it's a little bit of a different sort of thing. I don't know why I was getting to that, but I kind of wanted to lay out those two different scenarios because it's really important here to understand how much damage they've done to these people by preventing them from being able to publish the work through another person. They've interfered with a second contract. So anyway, it's big news. It's big news. I hope they prevail. I just hope they settle out. If Wizards has any brains, they will settle out. They'll give them some, they'll pay their attorneys and they'll go ahead and publish the books. Because at first glance, if they go to court on this, they're going to get wrecked. They're going to get wrecked by the initial sort of understanding. Again, they could come back with a very compelling story. Who knows? Maybe their dog died or something and they were in a dark place. They were sending their dick out to teenagers or whatever and they just forgot about it. And now they're sad, sorry, and they'll make it up to it. Who knows? Maybe Hasbro will force Wizards of the Coast's hand. Maybe Hasbro already did. We'll see. All right, guys. That's the main subjects tonight. So I'm going to go ahead, read the super chats and justice chats, and then we will go over to Twitch to do some movie action. We'll do the Scalia stuff maybe tomorrow. I wanted to do it, but I got a little wrapped up in the Biden and Trump stuff that went longer than planned. So we'll do the Scalia stuff tomorrow. That stuff's around forever and it's old news, so we can talk about it at any time. So I'll take it out of the title. But if you came here for that, sorry. But yeah, we are going to go over to Twitch. We'll start with House of 1,000 Corpses, and then we'll move to the church. The church. Should be fun. Should be fun, guys. Okay, let's get started. We've got Knight of Hopex says, I disagree with Nick. I think we take loving our enemies way too far in the modern church. We take the King James meaning of the Bible to mean we can't talk about politics or speak ill of anybody in power. It's a little ridiculous. To be continued. He says, loving your enemies biblically is more about not instigating ill will and treating others like adults, even when they talk down to you or abuse you. At some level, it's also about inviting dialogue by avoiding hypocrisy and listening to criticism, that stuff. Oh, damn, I missed this big chat from Anonymous. Sorry about that, Anonymous. It says, if you go through the entire article about the $750 figure, they admit further in that Trump actually paid about $5 million in taxes for those 2 years and told the IRS to keep it for future taxes he'll owe. $750 number is because he only owed $750. Yeah, I know. I didn't want to get too far into the weeds on it. But yeah, it's a very, very good point. Sorry I missed that earlier, buddy. Anthony James says, for the watch party last night, F in chat for our man Robert. All he wanted to do was fix trumpets and bang salutes, but in the end, all he got was zombie head. That was the best ending ever made. That was the best ending of any movie I may have ever seen. I'm not even joking. Edris Rex says, I can certainly believe Vic is like Joseph. Maybe he won't lead Egypt, but I'm pretty sure being thrown in a hole and sold into slavery is how all anime careers start. Crusader Saracen says, billionaires and billion-dollar companies leverage debt different than other people. Netflix is 10 billion in debt, and AT&T has over 60 billion in debt. Also, Legal Eagle is a bit of a chode. A bit of a chode. Legal Eagle is is premium tier chode. He's the kind of chode that men pay to lick, I guess. Knight of Hopex says, but loving your... Oh, wait, I read that one. No, I didn't. But loving your enemies cannot mean living in self-righteous hypocrisy and or moral cowardice, or refusing as a church to criticize the ideology of the political movements in our society. We simply don't live in a time where that's excusable anymore. Go. Kermit the Frog. Look, Hunter, it was fun hanging around you for all the hookers in the blow, but it's over. Those pics are weird as fuck, man. We're done. If I ever see you again, I'm pulling out the strap. In the best of all possible worlds, they would just leave children in peace, but they won't. I don't enjoy killing. But when done righteously, it's just a chore like any other. After all, we can't expect God to do all the work. What the fuck? Kermit the Frog also sends, I'm Father McFroggy. I come as fast as I could, but at my age, a little soldier needs a lot more thumping before it starts pumping, if you know what I mean. I do find, though, that if I tickle my asshole just before I unleash the dogs of war, it helps. Come on, man. Jew with a giant penis says, Oy vey, Rabbi Nicholas, do you know of a Jewish version of said manual for men with a gadol schmuck? Thought me and my Jewish circumcised penis face many challenges. We also must follow the words written in Hebrew. Any help, my friend, would be great. L'chaim. Oh my God. Why do you do this to me? Why do you do this to me? Kit says, if you're going to talk originalism, I would love to see talk about the Adrian Vermeule camp and their criticisms of it. Okay. Mario Carter 13 says, Curtis, vote Trump to pay 50 cents in tax Jackson. Mario Carter 13 says legal bank robbery, borrow money, don't return it. Yep. CJ says liar, unpaid child support equals jail time equals debtor prison. Child support is not a loan from a bank. Not a loan from a bank. What you do is you get a loan from the bank and then use that to pay your child support and don't pay the bank. Andrew War Snowboard says the Hunter Biden has become the hunted. A great birthday present one day early. God says you called. Mario Carter 13 says, where's Hunter? Coming soon to Funimation. Renkabot says, Greg Kelly rocks. I miss him on Fox in New York. Do you know who his dad is? No. I don't know anything about him. Peter Pete says, number 3 is FBI was holding on to tape to use against Joe in case he won. Maybe. Dan Willis, thank you for the donations. I read your thing earlier. 200 Watt Studio says, can you explain tort and tortious interference? So a tort is just an injury that you cause someone else. That's a tort. Personal injury. Damage to health, economics, reputation. Tortious interference is where you interfere with something in an injurious way. In a tortious way. So tortious is just the active tort, the act of committing a tort. Tortious interference, depending on some people get this mixed up, but depending on the type of tortious interference. Like tortious interference with a contract is a tort. Tortious interference with prospective business relations is not a tort. It requires an underlying tortious act. But yeah, that's the gist of it. Big Red Bear says, Wizards of the Coast is the Matt Jarbo of the tabletop RPG companies. What do they have against Sons of Magnus? Why they gotta hate? I don't know. I don't know, man. Well, there you go, guys. That's the show for tonight. Thank you all for coming. We will see you tomorrow. Tomorrow is Wednesday. Wednesday we will be, doing a show. I'm not 100% sure what the topics will be. There's so much to talk about, so we'll get something. We'll get something put together. Thursday will be the Ty Beard and me watch the presidential debate. We'll do that Thursday. Friday, I'm hoping we'll have a big brain panel on Friday. So, all right, guys. Thanks for hanging out with me tonight. I'll play this outro, and we'll see you over on Twitch. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Erlang. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us.
Oh shit, Keyboard Aspirin says WTF, be free tonight with Bride of Reanimator. That's Tommy Wiseau. Your music's a bit too loud.
So pour out an art bag of Balmore and Lafroy. Spirits flow as the ones who'd get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Painting tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for